There you go.
Thank you, Lance. Thank you very much.
Yep, you're good to go. Thank you.
I'm sorry, everyone. I'm not very technologically oriented, so I've got my husband who is sitting here helping me out in case I have issues. So if you hear a male voice coming through me, it's my husband, Willie.
Judge, you should have made Nancy Reisner help you.
Is there an echo? I think I have to do that. Can everyone hear me? No, I didn't. That's echoing. There's a delay, so that's why I did that. I can't hear them. All right. See, it's delayed. I'm arguing with my husband.
Can you hear me okay, Judge Lynch?
I can.
Is there a delay?
Yes.
Okay. And you see Mr. Rooney and Miss Starrett are the other judges. So.
Correct. See, there's a big delay. I do see that. It's like a minute. Does anybody know why there's such a delay?
I know that you had to exit out of, there was like if you had two tabs open, you had to exit out of the one or it would be echoing. That's the only thing I really remember that maybe could have caused it.
Okay.
And I'm not seeing a delay with Emily or you, Your Honor. Yeah,
Okay.
I'm not seeing anything either.
Or
Okay.
Sean.
Okay, then I think we're good to go, everyone. All right. Castle team, are you ready to proceed this morning?
Yes, Your Honor. The prosecution is ready to proceed.
And defense maroon team, are you ready to proceed?
Yes, Your Honor.
All right, I would like, before I go through the rest of the rules, could everybody, starting with the prosecution, could you identify yourself and also tell me and the scoring judges what role you're going to be playing?
Yes, Your Honor. Good morning. My name is Dylan Pearson. I will be delivering the opening statement, the direct of Alex Afontes, and the cross-examination of Avery Becker.
Okay, slow down a little bit. Say that again. You're doing opening and the direct of who?
Alex Afontes.
Okay. And cross of who?
Avery Becker.
Okay. Next team member, please.
Good morning, Your Honor. I'm Rosie Gonzalez. I'm going to be doing the direct on Kyle Kuzak and the cross-examination of Taylor Perkins.
Direct of Kuzak and cross of Perkins, did you say?
Yes, Your Honor.
Thank you. Okay, next team member.
Good morning, Your Honor. My name is Ailey Rubio, and I will be conducting the direct examination of Detective Jordan Markowitz, the cross-examination of Professor Blake Van Owen, and delivering the closing argument. May our witnesses introduce themselves as well?
Yeah, give me a second. Ms. Rubio, who are you crossing?
Professor Blake Van Owen.
Okay. And yes, please introduce your witnesses.
My name is Tyler Bobert, and I'll be Kyle Kuzak.
Okay, Tyler, what's your last name?
Bobert.
Thank you. Hey, thank you. You named it in there. That's very nice. Thank you. All right, other witnesses, please.
Hello, I'm Emily and I'm going to be playing Alex Fontes.
Okay. Thank you.
Hello, my name is Julian Engel Lewis. I am Detective Jordan Markowitz.
Thank you. And
What's
is that it for the prosecution?
Yes, Your Honor.
All right, Maroon team, would you please tell me who's going to be doing what examinations, and then I'll have you introduce the witnesses.
Good morning, Your Honor. I'm John Pumiali. I will be delivering the opening statement, cross-examining Alex Fuentes, and direct examining Taylor Perkins.
Good morning,
Okay,
Your
I'm
Honor.
sorry, Mr. Pumelli, tell me that again. You're doing opening and then cross and direct.
So I'm direct examining Taylor Perkins
Okay,
and crossing Alex Fuentes.
thank you. Sorry, I'm
Sorry.
I'm writing this down. You're okay. Next.
We also have one more team member, sorry TJ, that is having internet connection issues, but she's trying to join as soon as possible.
Okay, very good.
Thank you, Your Honor.
Honor, I
And-
just got a text from Lance and the scoring panelists need to turn off our cameras, I guess, right now. So we'll go ahead and do that.
Good morning, Your Honor. My name is TJ Newman. I will be direct examining Professor Blake Van Owen and cross-examining Detective Jordan Markowitz.
Okay, thank you. Is the other team member back yet?
I'm sorry, my internet is really bad right now. I'm not sure if you can hear or see me, but my name is, good morning, Your Honor. My name is Maya Geiger. I'm going to be direct examining Avery Becker and cross-examining Kyle Kuzak and doing the closing statement today.
All right, you talked really fast. Do that again. You're going to be doing direct of Becker.
Sorry.
That's okay. And then cross of who?
Yeah,
Cross of who?
Kyle Kuzak.
And you're doing
Kyle
closing.
Kuzak.
Yep, got it. And you're doing closing.
Yeah.
All right, are your witnesses there?
Yes, Your Honor.
And may the witnesses please introduce themselves.
Good morning, Your Honor. My name is Camille Denman, and I will be playing the role of Avery Becker.
Okay,
Good morning, Your Honor. My name is Bryn Geiger, and I will be playing the part of Taylor Perkins.
okay,
Good morning, Your Honor. My name is Kiara Warren and I will be playing the part of Professor Blake Van Owen.
very good. Thank you. And I want to remind everybody, I mean, this is the first time we've had to do this via Zoom. If a team member or a witness drops off, please let me know, because I will stop the proceeding and stop the time until that witness or attorney gets back online, okay? I don't want either team to be penalized for time-wise, but because they've dropped off. All right. I'm not really sure how we're doing the trial rosters. I think I just went through it because we're not in person. Usually you hand it to us. So is everybody satisfied that I've identified the trial rosters? Prosecution, are you okay?
Yes, Your Honor.
And how about Maroon team?
Yes, Your Honor. Thank you.
And I'm not sure about this video recorder thing either, because I don't know how you videotape a Zoom, but you can't video. Are there any video recorders present and being used? To your knowledge, prosecution?
No, Your Honor.
How about defense team?
No, Your Honor.
Okay. Because if anyone's using a video, it has to be with the okay of both sides. During the competition, the Bar Association might be taking photographs. I don't know how they're going to do that either. All right. I want to remind the teams that there's no recesses that are allowed unless there's a health emergency. Let's hope that doesn't happen. If there is difficulties with the technicality, I do have the discretion to stop the round. So like I just told you, if we do have some, please let me know, because I will stop it till everybody's back online. All right. Mr. Hershey, Ms. Starrett, and Mr. Rooney, do any of you have any reason that you might be biased in judging either team in this competition?
No, Your Honor.
So, okay. Sean, are you okay?
I am good.
Ms. Starrett?
Yeah, I
You
don't
good?
have either.
All right. Tony?
No, Your Honor, I do not. Thank you.
Very good. I want to remind both teams and the coaches that any disputes arising out of the competition have to be reported in accordance with the competition rules. And also remind the teams that your compliance with time requirements can be considered in scoring individual performances. And I want to confirm that no coach or team member other than a timekeeper is seated in the virtual courtroom. All right, I'm going to swear in the team members. Team members, if you'd please raise your right hands. Team members, do you promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you. And witnesses, if you'll raise your right hands. Do you promise that the testimony you're about to give will faithfully and truthfully conform to your witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules of the mock trial competition?
Yes, Your Honor.
Yes, Your Honor. Your Honor.
Very good. Gallery members, including teacher and attorney coaches, please raise your right hand. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this competition? I'm assuming they're saying yes. Scoring panelists, if you'll raise your right hands. Do you promise to adjudicate the mock trial competition as fairly and objectively as possible in accordance with the facts, procedures, and rules of the competition? Just, you can shake your head. Thank you. All right, and with that, I believe we are ready to begin. Castle team, are you ready?
The prosecution is ready to proceed.
All right, Maroon team, are you ready?
Yes, Your Honor, we are ready to proceed.
Very good. All right, then let's let the games begin. Go ahead, Ms. Fearson. Do you have any preliminary matters?
Yes, Your Honor. We ask that the time be stopped in case of any technical difficulties. And
That will be so, that's a given.
Thank you. We have stipulations and trial rosters to share with the bench and the jury.
Okay,
Exhibits have already been shared with opposing counsel, but we are still going to ask that the record reflect we are sharing them again when we move to admit them to be examined for identification purposes.
very good.
And even though this is a virtual tournament, we are going to ask that the court allows exhibits to be, once admitted, to be left on the witness stand. That way they may refer back to it throughout their testimony.
Okay,
Thank you.
but advise your witness they can't look at it until it's brought to their attention.
Yes, Your Honor.
Anything else, Ms. Fearson?
No, Your Honor.
All right. Mr. Pumali.
Thank you, Your Honor. I would like to constructively provide a copy of stipulations to Your Honor and inquire whether the jurors have copies as well.
I think they have copies virtually.
Thank you, Your Honor. In terms of admitting exhibits, co-counsel and I will be asking permission to screen share exhibits for purposes of establishing foundation, and then we'll specifically ask to publish.
That's fine.
We would ask permission to stay seated during our presentation for purposes of audiovisual quality during these proceedings.
Yes, please do that. Both teams, I want you to do that.
Lastly, Your Honor, we would ask permission to raise our hand as we object in order to alert the court that we have an objection in lieu of standing again to maximize audiovisual quality.
Oh, that's a good idea. Okay.
Thank you, Your Honor. I have no further preliminary matters.
All right. Then Ms. Fearson, we're ready for your opening statement.
Yes, Your Honor. May it please the court. Your Honor, opposing counsel, ladies and gentlemen of the jury. In the words of Juvenal, revenge is always the weak pleasure of a little and narrow mind. And during today's trial, you'll see this exact behavior in Avery Becker. The death of Mackenzie Brackman was no mere accident. His death was a result of Avery Becker's anger that has been building up for years. Mackenzie Brackman was a lawyer who devoted the majority of his time and efforts into teaching the young adults of the Colorado high school the way of the law. His expectations were high, and he left no room to mess around in his courtroom. This didn't sit well with Avery Becker, for she believed she was the best on the team and therefore didn't need to put in any effort into their work. When Coach Brackman noticed this lack of effort on Avery's behalf, he demoted her, knowing she was not A-team material. This enraged Avery Becker, causing her to manipulate her friend Taylor Perkins into quitting the team only so she could get exactly what she wanted. And after a reckless performance at regionals, Mr. Brackman knew he couldn't let Avery ruin their team's chances at winning state. And when he tried to explain to her she shouldn't have confused good showmanship with good lawyering, she stormed out, enraged and wanting revenge. She took out her anger on Mr. Brackman by writing Worst Attorney Award in permanent marker on the hood of Brackman's vintage 1986 Porsche 11, which ruined the paint. Her actions only added fuel to the fire and resulted in her being kicked off the mock trial team entirely. After many desperate attempts to get back on the team, Avery Becker snapped, and when Mackenzie Brackman refused to speak to her, she had already planned her revenge. Ladies and gentlemen of the jury, Avery Becker is on trial for second-degree burglary of a dwelling and murder in the first degree. What does this mean to you? This means Avery Becker intentionally and unlawfully broke into Mackenzie Brackman's house with the objective to commit second-degree burglary, and in the course of action, stabbed Mackenzie Brackman, causing him to bleed to death. We, the prosecution, have the burden of proof, which means we must prove every element beyond a reasonable doubt. And today, we will provide you with evidence that proves on March 6, 2020, in Denver County, Avery Becker broke into Mackenzie Brackman's home with the objective to vandalize it, and in the course of action, stabbed Mackenzie Brackman, which has escalated to not just second-degree burglary, but murder in the first degree. Today, you will see text messages between Alex Cefontes and Avery Becker, which clearly state Avery intended on breaking into Mr. Brackman's house to trash the place, all while he was away at work. We will provide you with cell tower data, which will prove Avery Becker was at Mackenzie Brackman's house on March 6th. You will even hear her best friend, Taylor Perkins, refer to her phone as a third kidney. It's not likely she would just lose it. And finally, you will hear from two experts in their field that have both come to the same conclusion. Based off the evidence they have gathered in today's case and a careful analysis of this evidence, they have come to the conclusion that Avery Becker did in fact murder Mackenzie Brackman. As we've already discussed, we the prosecution have the burden of proof. And by the end of today's case, we will prove Avery Becker wanted to go to Mackenzie Brackman's house to trash the place. We will prove she wanted her revenge on the man she believed ruined her mock trial career and was going to do anything to see her revenge through. And we will prove that she showed up at his house on March 6th and murdered him. We ask that you're mindful of the fact that Avery Becker knows her way around the courtroom and can manipulate the law to her own well-being. It is your right as a jury to believe all, some, or none of a witness's testimony. At the end of this trial, my co-counsel, Ailey Rubio, will deliver the closing argument. The judge will then read you the law, and when she's reading you the law, she will explain that direct evidence and circumstantial evidence are given the same weight, and both are acceptable in a court of law. Direct evidence being something you see, and circumstantial evidence being evidence that points to the same conclusion. Ladies and gentlemen of the jury, by the end of this trial, you will see we have met our burden, and we ask that you return a verdict saying Avery Becker is guilty of second-degree burglary of a dwelling and murder in the first degree. Thank you.
Thank you, Ms. Pearson. Mr. Pumali.
Thank you, Your Honor. In this case, we take a look at a horrible murder of a high school mock trial coach, Mackenzie Brackman. On March 6th, he was found dead in his home. The police, after a short investigation, rushing to get it wrong, jumped to the conclusion that he was stabbed to death by his former mock trial student, Avery Becker. Hi, I'm John Pumiali, and I will be giving the opening statement for the defense in this case. We are asking for you to truly see how Avery Becker is not guilty. There was a rocky past in the mock trial team, but that is expected. Uniting many teenagers under the supervision of limited adults is hard, and there will always be some rebellion creating conflicts, but never enough to end someone's life. The opposing counsel will take advantage of the past that Avery and Coach Brackman have had just because she doesn't belong in a societal system where she is expected to act like a robot under the constricting instructions of Coach Brackman. We all have a time in life where we don't feel like we fit into an educational system we are in, and that's okay, but it should never be enough to unrightfully send someone to jail. Young Becker has also had a few disagreements with Alex Cifuentes. Alex Cifuentes is currently a senior at Colorado High School, which we will refer to as the CHS. She was a passionate junior the year of the incident. Because of her relationship with Coach Brackman, she couldn't see this case in an unbiased way. She had gained a close connection with Coach Brackman, influencing Alex's point of view in this case. Due to her very tainted perspective, she is an unreliable witness. Cifuentes looked up to Mr. Brackman and wanted what's best for him, but she also wanted what's best for herself. The defense has evidence to show how Alex Cifuentes is an unreliable source for this case. We are worried that her obsession with success has brought on heavy, dangerous emotions such as greed and the fear of failure. When influenced by such emotions, people will go far distances to ensure they get what they want. In for a penny, in for a pound, right? In this case, you will proceed to see faulty evidence that happens to favor the point of view of the prosecution. On top of unreliable evidence, the state will try to convince you that the unidentifiable figure in the videos is Avery Becker, with a highly common build. Kyle Kuzak and Jordan Markowitz are trying to solve this puzzle as quickly as they can, to rush to justice. But one wrong move and justice rapidly becomes the incorrect word for the outcome. Kyle Kuzak and Jordan Markowitz are rushing to get it wrong with puzzle pieces that don't even connect. Some puzzle pieces are non-reliable as they are fake and manipulated. Avery Becker is an innocent civilian who graduated from the Colorado High School the same year as the killing. Is it acceptable to blame an innocent young adult for the killing of a man? A wrongly directed sentence could ruin the life of a brilliant young being. Judge, members of the jury, in front of you today I ask you, would you hurt Avery Becker's future for the inability of accurate evidence presented by adult witnesses? I think not. My counsel will prove to you how this evidence is not enough to jump to such a huge conclusion. The evidence shows no confirmed identity of Avery Becker at the crime scene. Each of our witnesses will show that Avery Becker is not guilty beyond reasonable doubt. Our expert witness, Blake Von Owen, has an official report showing Avery's whereabouts with Taylor on the day of Brackman's death. Our witness, Taylor Perkins, will testify that Avery was with her during the day of the killing, therefore making it impossible for it to have been Avery. Thank you.
Thank you. All right, will the Castle team call their first witness?
Your Honor, prosecution calls Kyle Cusack to the stand. May I begin?
You may.
Good afternoon. Could you please state your full name and spell the last for the record?
My name is Kyle Cusack. My last name is spelled Kuzak.
Mr. Cusack, what do you do for a living?
I am a Colorado Bureau of Investigation Certified Crime Scene Reconstruction Investigator, also known as a CSR.
And what is a crime scene investigator?
They investigate multiple complex crimes, also simple crimes such as home invasions, burglaries, and other property crimes, homicides, domestic violence, fatal accidents, and armed robberies.
And for how long have you been doing this?
I have been doing this for 19 years at the time of writing my verbatim.
Mr. Cusack, who is it that you work for?
I work for the Denver Police Department.
So does this mean that you're a police officer?
I am not a police officer. I am a civilian employee of the Denver Police Department.
Can you tell us a little more in depth about what cases you've worked in?
I've worked in all cases, big or small, from burglaries to homicides.
Your Honor, I now move to admit Kyle Cusack as an expert witness in the area of general crime scene investigation, complex crime scene investigation, and crime scene reconstruction.
Any objection?
Yes, Your Honor. May I proceed with voir dire of the witness?
You may. And is this Ms. Geiger?
Yes, Your Honor.
Okay, thank you.
Mr. Cusack, you're not a police officer, are you?
No, I'm not.
You're a civilian employee of the Denver Police Department,
Yes, I am.
where you've been working for the past 3 years?
Yes,
And you testified that you have 19 years of experience investigating crime scenes, right?
yes, I do.
But we don't have a copy of your CV, including where you worked or where you went to school, do we?
No,
Your Honor, we object to qualifying Mr. Cusack as an expert witness under Rule 702. The only information we have that he is certified in crime scene reconstruction with 19 years of experience is his own testimony. We don't even know where that experience was, when or how he was certified, and what education he has.
Your Honor, may I respond?
Yes, please.
Your Honor, pursuant to Rule 702, an expert witness must have education, training, or experience. My witness has shown that he has experience and training as he's worked with the Denver Police Department for 19 years.
702 doesn't require education. It can be based on skills and employment. And so I will allow Mr. Cusack to render expert opinions in the area of accident reconstruction.
Thank you, Your Honor. May I proceed?
You may.
Mr. Cusack, tell us more about how you complete an investigation.
I have a 5-step process, which could be the same for even baking a cake. First, you would open the cookbook, try to find all the ingredients that you would need to bake a cake. Then go to the store, collect all of your ingredients, take it home, make sure you have all your ingredients, all the right portions, mix it all together. Then throw it in the oven, take it out, eat it, and go tell your mom how great you did on your cake.
Objection narrative.
Overruled.
Your Honor, may I proceed?
You may.
Mr. Cusack, how well would you say that this process helps you in a case?
It works most of the time. It follows the same process as the scientific method, so I have full trust in it.
Your Honor, let the record reflect that I am showing opposing counsel Exhibit 17.
Very good.
Your Honor, may I now show the bench and witness a copy of Exhibit 17 for identification purposes?
You may.
And just one moment as we're having some slight technical difficulties. Mr. Cusack, can you tell me what this exhibit is?
This is my witness tracking sheet.
And do you keep this document in your regular course of business?
Yes.
Would you say this document is updated regularly?
Yes.
And is this an accurate depiction of your witness tracking spreadsheet for that date?
Yes, it is.
Your Honor, I now move for the admission of Exhibit 17 into evidence.
Any objection?
Yes, Your Honor. I object under lack of foundation.
Can I respond, Your Honor?
You may.
Pursuant to Rule 8036, this is the business record exception because this is kept in his regular course of business. He's the keeper of this, and this record is used regularly in his course of business. Your Honor, if you would allow me to lay foundation, then I would be able to talk more about this exhibit.
Go ahead.
Your Honor, may co-counsel publish this exhibit to the jury?
You may.
Mr. Cusack, do you have any suspects on your chart?
Yes, I have 3 suspects: Avery Becker, Alex Afontes, and Blair Rollins.
Mr. Cusack, can you tell me why Alex is a suspect in this case?
Alex Afontes has had a history with Mr. Brackman and was a member of the mock trial team that was coached by Mr. Brackman, and has had screenshots with Avery Becker.
And Mr. Cusack, can you tell me why Avery Becker is on this spreadsheet?
She is also a former member of the mock trial team, and she has had also a history with Mr. Brackman, riding on his vintage Porsche and threatening to go to his home and destroy more property.
And Mr. Cusack, can you tell me why?
Objection, improper characterization.
Overruled.
And Mr. Cusack, why is Blair Rollins in this spreadsheet?
Blair Rollins' father was had Mr. Brackman as their defense attorney, and he did poorly as a defense attorney, and they said that whenever he was convicted, they threatened to kill him.
And Mr. Cusack, who would you say your top suspect?
Objection, hearsay.
Your Honor?
To the former
Yes.
question, sorry.
I didn't have time to finish my question before.
I agree. Finish your question and then she can object.
Mr. Cusack, who would you say, in your expert opinion, is your top suspect in this case?
Avery Becker.
And can you tell us why that is?
Because after my 5-step process, all of my evidence has pointed directly towards Avery Becker instead of any of the other suspects.
So with your expertise and knowledge, can you tell us what your conclusion of this case is?
Avery Becker went to Mr. Brackman's house with the intention to do property damage, but was unexpectedly met Mr. Brackman at his home and stabbed him in the back.
Objection, improper characterization. It has not been proved yet that Avery Becker was the perpetrator. And by Mr. Cusack saying that Avery Becker was a perpetrator, it gives, I would like to change my objection to prejudice outweighs probative value. The statement by the witness just now has substantial prejudicial value.
May I respond, Your Honor?
You may.
Again, pursuant to Rule 702, an expert witness must have education, training, or experience. My witness has already been admitted as an expert witness, so he can make expert opinions on this case.
May I respond?
You may.
I agree that the witness can make expert opinions. I just don't, he's not qualified to make the opinion about who the suspect was or who the perpetrator was. And he is not qualified in this field, and this should not be allowed because it's not part of his testimony.
Yeah.
Overruled. Overruled.
May I restate my question?
You may.
Mr. Cusack, with your expertise and knowledge in this experience, what would you say your professional conclusion of this case is?
Well, I've looked at all three suspects, but the only suspect that I've gained anything from was Avery Becker. All of the evidence that I've looked at has only pointed towards her, and it wouldn't line up with any of the others.
That is all, Your Honor. Thank you.
Thank you. Cross, Ms. Geiger?
Yes, Your Honor. Mr. Cusack, my name is Maya Geiger and I represent Ms. Becker, and I'll be asking you some questions today. So you testified that you have 19 years of experience in investigating complex crime scenes, right?
Yes, I do.
And that you are a certified crime scene reconstruction investigator?
Yes.
So would you agree that it is important to gather all relevant evidence
Yes.
and keep that relevant evidence safe?
Yes.
Would you also agree that it is absolutely crucial to conduct a thorough and comprehensive investigation before identifying a suspect?
Yes.
Okay, so let's talk about your conclusions in this case and what they were based upon. So you concluded that on March 6, 2020, a perpetrator matching the general height and build of Ms. Becker approached the victim's residence, right?
Yes.
Initially stepping on the front porch and checking the front door, right?
Correct.
And then proceeding to the south side of the residence, right?
Correct.
But the perpetrator was not identifiable on the ring videos, were they?
No.
And no DNA was recovered from the gate.
No, she was wearing gloves.
Okay. And no fingerprints were additionally recovered from the gate, were they?
As I said, she was wearing gloves, so no.
Okay. And you can tell by looking at the ring footage the age of the perpetrator, correct?
Correct.
Or the gender of the perpetrator?
Correct.
Or the race of the perpetrator?
Correct.
And you testified that the individual in the video generally matched the height and build of Ms. Becker,
Correct.
but you didn't include the height and build in your findings, did you?
As I could only see the ring video, I can't testify his exact height or weight or anything like that.
Right, okay. So neither you nor anyone else has ever been able to identify from the ring videos who the perpetrator was, correct?
Correct.
And based on the physical evidence of the scene, you concluded that the victim must have been alerted by the ring security system.
Correct.
And then the victim grabbed a knife from his knife block, right?
That's what I believe, yes.
And then confronted the intruder in the kitchen, correct?
Correct.
And then was disarmed by the intruder. And the intruder then, as part of a struggle, reached over and stabbed the victim in the upper back shoulder area, right?
Correct.
Okay. And before you made your conclusions, you interviewed Detective Markowitz, didn't you?
Sorry, I do not recall.
Would you like to look over your witness statement?
Yes.
Okay. Your Honor, I request permission to screen share.
You may.
Okay, so can you read lines 8 through 10, please?
I visited the scene of the homicide at 444 South Flower Street after it was preceded by other members of the crime lab. I also reviewed all of the police reports in this case, photographs from the scene, and for ring security camera videos.
So after reviewing your statement, do you still stick by the statement that you didn't review Detective Markowitz's statement?
You questioned if I interviewed Detective Markowitz.
Objection, Your Honor.
What's your objection?
This attorney has asked if Kyle Cusack has interviewed Mr. Markowitz, but what she read in the affidavit has nothing to do with her question.
May I respond?
You may.
The lines that the witness just read referred to his reviewing of the police officers in this case and the detectives. Jordan Markowitz is a detective in this case, and so it can be concluded that Kyle Cusack interviewed Detective Markowitz for this case.
That's a reasonable inference. I'll allow it.
Information.
Thank you. May I re-ask the question?
Yes.
Okay, so before you made your conclusions, you interviewed Detective Markowitz, didn't you?
Correct.
And in fact, the flowchart you made was derived partly from your interview with Detective Markowitz too.
Correct.
And you also read his report, right?
Correct.
Okay, and Detective Markowitz had a theory that Avery Becker was a suspect, didn't he?
Yes.
And you were aware of that theory?
Yes.
And you even include that theory in your flowchart, don't you?
No.
Well, in your flowchart, you concluded that Avery Becker was partially suspect, correct?
Don't remember seeing any Avery Becker in my flowchart.
So you don't conclude that Avery Becker is a suspect?
I do say she's a suspect.
So then you would agree that in your flowchart, you concluded that Avery Becker was a suspect, which was derived from your interview with Detective Markowitz, who had a theory about this case that Avery Becker was a suspect, correct?
My flowchart is only to show what happened during the event, not to show who the suspect was.
Okay, I can move on then. So one of the ways you arrived at your conclusions was by organizing all your photographs into a spreadsheet to reveal a clear timeline, correct?
Correct.
And the timeline you made indicated to you that the victim was stabbed near the kitchen, correct?
Correct.
And then proceeded to the front door and pulled the knife out and dropped it there, correct?
Correct.
And some of the photos you reviewed for your investigation were of blood droplets and blood cast off, correct?
Correct.
But those photos were corrupted, weren't they?
Yes.
We don't have them.
Yes, the data was unrecoverable.
And to reiterate, the jury can't see those photos, correct?
No, they cannot.
And you testified that the scuff marks on the kitchen floor near the back door indicate a struggle in the kitchen, correct?
Yes, I do.
But you have no way of independently verifying the age of those scuff marks, do you?
No, I do not.
And you concluded that the knife block was missing a knife, correct?
Correct.
But you have no idea if that knife was lost on some other date, do you?
No.
And the knife that killed Mackenzie Brackman didn't match the knives in the knife block exactly, did it?
No, but also in the drawer, there were multiple mixed knives.
Okay. And there was no evidence on scene that any of Mackenzie Brackman's personal items were destroyed or stolen, was there?
No.
Okay, so let's talk about the fatal injury a little bit. Mackenzie Brackman died of a single stab wound to his left scapula, penetrating into his thoracic aorta, correct?
Correct.
And the scapula is a bone?
Yes.
It would have taken a great amount of force, wouldn't it have, to penetrate the scapula all the way into the aortic valve?
Correct.
And you believe this fatal wound occurred during a struggle, correct?
Correct.
That the perpetrator reached all the way around and stabbed Mr. Brackman?
Well, it doesn't have to go all the way around. They could have got him from behind, just somehow got behind him.
Okay.
Not really.
However, you didn't gather any information about whether the suspect was taller or shorter than Mackenzie Brackman, did you?
No.
And you also didn't know if the suspect would have been right or left-handed, did you?
No.
Objection, relevance?
And
May I
what's
respond?
relevance, Ms. Geiger?
This is completely relevant because it is discussing the wound and Kyle Kuzak's theory of how the wound occurred and how the killing of Mackenzie Brackman occurred, which is extremely relevant to the theory of the case for both sides.
Overruled.
May I repeat my question?
You may.
So you concluded that Mr. Brackman himself reached around and pulled his own knife out of his shoulder
Yes.
after he was injured?
Correct.
The knife was facing partially forward at an angle, correct?
Correct.
And this would have taken a great amount of force to remove out of his own body, wouldn't it have?
Correct.
So you said that you dismissed the likelihood that an intruder stabbed the victim from behind while seated at the kitchen table because the victim would have been surprised by the intruder, correct?
Correct.
But you have no idea what Mackenzie Brackman was doing when the intruder came into his house, do you?
No, I did not.
You don't know if he was listening to music.
Objection, relevance?
Overruled.
May I repeat the question, Your Honor?
You may.
You don't know whether he was listening to music.
Correct.
Correct. Or singing in his bathroom.
Sorry, could you repeat that?
Right, okay. I can just move on. I was just giving some examples. So you can't tell the exact location in the house of the stabbing, can you?
I know it happened around in the hallway.
Right, but you can't tell the exact location, can you?
No.
Because there was no blood spray or cast up blood splatter droplets until the victim pulled the knife out, correct?
I believe there were blood splatter droplets from the original stabbing.
Right, when the victim pulled the knife out, correct?
No, when he was first stabbed.
Okay. Lastly, Mr. Cusack, your opinion on this case does not include who the killer was, does it?
No.
Because you cannot make that opinion based on the physical evidence in this case, can you?
No, I cannot.
No further questions.
Redirect, Ms. Gonzalez.
No, Your Honor.
Thank you. Thank you, Mr. Kuzak. All right, call your next witness, please.
Yes, Your Honor. The prosecution calls Alex Cifuentes to the stand.
Mr. Cifuentes, will you raise your right hand? Do you
Sorry about
swear?
that. I was having some technical difficulties.
Oh, okay. I'm just going to swear him in real quick. Mr. Cifuentes, do you swear, or Ms. Cifuentes, do you swear or affirm under penalty of law the testimony you're about to give will be the truth?
Yes.
Thank you.
May I begin, Your Honor?
You may.
Thank you. Good morning. Can you please state your name and spell your last name for the record?
My name is Alex Cifuentes, Sifuentes.
Ms. Cifuentes, are you currently attending school?
Yes.
Where?
I'm attending school at Colorado High School.
And do you participate in any extracurricular activities?
Yes.
What?
I participate in mock trial.
Ms. Cifuentes, what's mock trial?
Mock trial is a simulated court case where we basically go through the motions of an actual court case, like just like a regular court case.
And do you know who Avery Becker is?
Yes.
How do you know Avery Becker?
We actually get on mock trial.
And what's it like being on a mock trial team with Avery Becker?
Very difficult. She never comes prepared. She's very spacey, I would say.
And has this behavior ever affected your team before?
Yes, it caused tension between all of our team members, and often we would argue, especially her and coach.
And can you give us some examples of these arguments?
Her and Mr. Brackman had actually gotten into a fight right before regionals, which demoted her to B team, which made her so angry. She was angry, sorry.
Objection, Your Honor. Hearsay under Rule 802.
Your Honor, may I respond?
Yes.
Pursuant to Rule 801, hearsay is an out-of-court statement being used to prove the truth of matter asserted. This is not going to the truth of matter asserted. This is going to the effect upon the listener.
Overruled.
Thank you, Your Honor. May I proceed?
You may.
Ms. Cifuentes, allow me to restate my last question. Can you give us some examples of these arguments?
Right before regionals, her and coach had been arguing because she showed up yet again not prepared. And while arguing, she got demoted to B team, which made her very angry. And then during right before state, her and Mr. Brackman got into yet again another argument, and she took a permanent marker out to Coach Brackman's car and wrote "worst attorney" on the side of it. His vintage Porsche.
Were there any consequences for her actions?
Objection, Your Honor.
What's your objection?
Improper character evidence under Rule 404B.
Your Honor, may I respond?
You may.
I've previously laid foundation that the witness knows Avery Becker and has spent plenty of time with her within mock trial, and therefore I believe it's fair that she may testify to events that happened at a mock trial practice.
Yeah, I'll allow it. It's based on her personal knowledge.
Thank you, Your Honor. Ms. Cifuentes, were there any consequences for her actions?
After she wrote Worst Attorney Award on his vintage Porsche, she was kicked off the team permanently.
Did you ever speak to Avery Becker after that?
We actually ran into each other at the Fry Shack shortly after.
And what happened at the Fry Shack?
At the Fry Shack, she had started a conversation. We talked a little bit, and I gave her some advice about how to go forward in the future and to better get over the issue, so she's not caught up on it. And she was very thankful and let me play games on her phone that day.
And did you ever hear from Avery after that?
We had a text conversation before Mr. Rackman's death.
Your Honor, let the record reflect I have previously shared Exhibits 14 with opposing counsel.
Record will so reflect.
May I screen share Exhibit 14 for identification purposes?
Yes, you may.
Thank you. Ms. Fuentes, can you tell me what this exhibit is?
This is a text conversation between me and Avery Becker.
Mr. Pumali has his hand up.
Yes, thank you, Your Honor. Objection under Rule 901 for lack of authentication.
Okay. I think she's trying to lay the foundation right now.
Of course. Thank you, Your Honor.
Thank you. Ms. Fuentes, what is this?
This is a text conversation between me and Avery Becker.
And how do you know what this is?
I actually sent these in to Detective Markowitz, sorry.
And are these an accurate depiction of the messages between you and Avery Becker?
Yes.
Your Honor, I now move to admit Exhibit 14 into evidence.
Yes, Mr. Pumali.
Thank you. Objection under Rule 901 for lack of authentication.
Your Honor, may I respond?
You may.
If you allow me to proceed with my questioning, I will continue to lay foundation as to the authenticity of these text messages.
Well, you have to lay the foundation before she can go into the meat of the text messages because they're not admitted as an exhibit yet. Did you want to just lay additional foundation?
Yes, Your Honor.
Okay.
Ms. Fuentes, who sent you these messages?
Avery Becker.
And how do you know this?
Because the contact name at the top?
Yes. Your Honor, I now move to admit Exhibit 14 into evidence.
Mr. Pumali.
Thank you. The evidence also shows lack of reliability because they are screenshots as they could have been manipulated.
Your Honor, might I respond?
You may.
The witness has testified that these were the best, this was the best evidence they could provide and no longer have the cell phone that had these text messages on it.
I'll allow it. They've been identified as hers. They're properly authenticated. Exhibit 14 is admitted.
Thank you, Your Honor. May we publish Exhibit 14 to the jury?
You may.
Thank you. Ms. Fuentes, with this conversation with Avery, did she ever say anything that really stood out to you?
Yes. May I quote a message between us?
Yeah, of course.
Okay. A message that really stood out to me in this text conversation that we were having was, she said, well, if he's upset about his car, then he's going to be really upset when he sees what I do to his house.
Ms. Fuentes, do you gain anything by falsifying text messages from Avery Becker?
No, she was my best friend.
Do you know why you're here today?
Yes. I'm here to bring justice to Mr. Brackman's death.
And were you involved in the investigation at all?
Yes. Very shortly after Mr. Brackman's death, I was brought in for questioning.
And did you provide anything during this questioning?
Yes, I provided screenshots of me and Avery Becker's conversation.
And how did you provide the detective with these messages?
I provided them via email because I left my phone at home.
And why did you leave your phone at home?
During that day, I had not left my phone on the charger at night, so I had to plug it in the morning for the interview, obviously. And when I had left the house, my dad and I were already late to the interview, so he didn't want to make me even more late. So I just left it on the charger and just ran out the door. I totally forgot. It spaced my mind.
Ms. Fuentes, do you still have this phone?
No.
And do you have anything against Avery Becker?
No, she was my best friend, as I previously stated.
Thank you, Your Honor. No further questions.
Okay, and can you take the exhibit off the share screen, please? All right, Mr. Pumali, Cross.
Yes, thank you, Your Honor. Today is February 27th, correct?
Yes.
And just as a reference, you're aware that Mr. Beckman was found dead March 6th?
Yes, sorry.
Of course. And the year of the incident, you were a junior at the Colorado High School, right?
Yes.
Thank you. You say that Avery and you were practically best friends.
Yes, we were best friends.
Could we say that you put more time into mock trial than Avery did?
Yes.
And you came prepared nearly every session?
Every session I came more than prepared.
And what about Avery? You say she was barely prepared for meetings?
She was never prepared for meetings. Most of the time she just made up what she was thinking on the spot.
And in your witness statement, you say Avery always played the victim and refused to work hard. Is that still accurate?
I never said she played the victim.
In your testimony, you do have a line where you testify to Avery playing the victim. Would you like to review your affidavit?
Yes, please.
Of course. Excuse me, Your Honor. Let me look for the evidence, as for some reason it is not on my screen.
Uh-oh. Okay.
I'm pulling it up right now. Okay, let's see. All right, Your Honor, may I please share my screen?
You may.
Thank you. Excuse me, Your Honor. I'm sorry for the technical difficulties.
No problem. We're all having issues.
All right. Could you please, here we go. All right. Could you please read lines 21 through 23?
Sorry, I forgot I was muted. Mr. Brackman was always telling Avery to do a better job of preparing for practice and preparing for tournaments, but Avery refused, and Avery hated Mr. Brackman for this. Avery always played the victim and refused to work hard.
All right. Thank you. So do you stand by what you previously said?
No, sorry.
Yes, of course. Oops, sorry, I need to get this back in touch. I don't know why everything is kind of crazy right now, Your Honor.
Take your time.
In the beginning of your witness statement, you also say we were almost equally skilled as team members, referring to you and Avery, correct?
Yeah, she was very talented, just never prepared.
So in other words, you put many more hours into the team and hard work, yet you were equally skilled.
Yes.
You say Avery won the Best Attorney Award and Best Closing Statement Award at the regional tournament. Is that right?
Yes.
Objection, Your Honor.
What's your objection?
That was a compound question.
Overruled. I don't think it was. Do you want to re-ask it, Mr. Pumali?
Yes, of course. In your witness statement, you say, and I quote, Avery Becker won the Best Attorney Award and Best Closing Statement Award at the regional tournament, close quotes. Is that right?
Yes.
Avery won 2 major awards and at the mock trial tournament, and you won none. As a more contributing mock trial team member, did this make you upset?
Of course I was a little disappointed, but I was happy for Avery.
Now, let's take a look at Coach Brackman. You described him as awesome, and you are a big fan of his 911 Porsche.
Yes. He had a very beautiful car.
You also think he is a talented litigator.
Yes.
Could we say that you admired him?
Yes.
And you believe that someone should rightfully pay for his death?
I do.
Would you say that you're an average phone user?
Objection relevance?
Would you repeat the question, Mr. Pumali?
Would you say that you are an average phone user?
What's the relevance of that, Mr. Pumali?
I'm trying to establish as to I'm trying to ask Alex Cifuentes for reasoning as to why she did not have a phone with her during the interview for this case.
I'll allow it.
Thank you, Your Honor.
Thank you. Would you like me to restate the question?
No. Yes, I was an average phone user.
The probability that you leave your phone somewhere on accident is slim, isn't it?
Slim, but not impossible.
Of course. And so forgetting to charge such a commonly used tool in your life is also a slim probability.
Again, slim, not impossible.
Now, if Avery was your best friend, why would you need to introduce herself or introduce yourself in your text conversation?
I'm sorry, can you restate the question, please?
If Avery was your best friend, why would she need to introduce herself in your text conversation?
I don't know.
Okay, thank you. You forgot your phone the day of the interview?
Yes.
All right, thank you. No further questions, Your Honor.
Redirect?
No redirect necessary, Your Honor. Thank you.
All right, thank you. All right, will the Castle prosecution call their next witness?
Yes, Your Honor. The prosecution calls Detective Jordan Markowitz to the stand.
All right, Mr. Markowitz, would you raise your right hand, please?
Of course.
Do you swear or affirm under penalty of law that the testimony you're about to give will be the truth?
I do.
And Julian, just for the scorekeepers, what's your last name?
Ingle Lewis, INGLE hyphen Lewis, LEWIS.
Thank you. You may proceed.
Good morning, Detective. Can you state your name for the jury and spell your last name?
Of course. My name is Detective Jordan Markowitz, MARKOWITZ.
And where are you currently working, Detective?
I'm currently working with the Denver Police Department.
And how long have you been working with them?
I've been a parole officer for 6 years and I was promoted to detective. I've been working as one for 7.
Do you have any certifications that help you as a detective?
Of course. I'm certified in cell tower data recovery, cell phone data analysis, and forensic data recovery.
And what did you learn through this training?
Well, I learned how to use cell towers to find an accurate location of a phone.
Oh, Mr. Newman, I'm sorry. Did you have an objection?
Your Honor. The question assumes facts, not evidence. It has not been established that he received any training, and she asked about what he learned during that training.
Your Honor, may I respond?
Yes.
The witness has previously testified that these are the certifications he received, and I am establishing what he learned through this training via the certifications.
Certifications and training are different things, and I believe that you need to establish that he has training if you want to ask questions about what he learned in that training.
Your Honor, may I respond?
You may.
Your Honor, pursuant to Rule 802 or 702, an expert witness needs education, training, or experience. Certifications require training to get these certifications, which is what I'm trying to establish to admit him as an expert.
All right, well, why don't you ask him what trainings he had?
Yes, Your Honor. What training have you received?
Well, I've worked in hundreds of cases, and I spent the entire 6 years as a parole officer trying my hardest to get up to detective.
And after this?
Well, I had received training in using the Celebrite system, using cell towers to find an accurate GPS location of persons during a certain date and time, and how to properly analyze a crime scene.
And do you use this training as a detective?
Of course, I've used this training in hundreds of homicide cases.
And do you use your certifications as a detective?
Of course, almost every single one of them.
Your Honor, we now ask that the court recognizes Jordan Markowitz as an expert to render opinions in criminal investigation, specifically homicide investigation, cell phone data analysis, cell tower data analysis, and forensic data analysis.
An objection?
No objection, Your Honor.
All right, he will be allowed to render opinions in cell tower and criminal investigation.
How are you connected to the Mackenzie Brackman case?
I was assigned the case on March 6th of 2020.
And did you ever visit the crime scene?
I did. I was one of the first responders.
And what did you see upon first arrival?
Well, when I had showed up, I had found Mr. Brackman dead at the front door.
And were there any photos taken of this crime scene?
Of course.
And Your Honor, let the record reflect that I have previously shared exhibits 1, 2, and 4 with opposing counsel.
Record will so reflect.
Your Honor, may I share exhibits 1, 2, and 4 with the bench?
You may. You may.
Detective, do you recognize these pictures?
I do, yes.
And what are they?
These would be photos taken of Mr. Brackman as found at the scene of the crime.
And are they a true and accurate depiction of what you saw at the crime scene?
Yes, they are.
And do you use these photos regularly as a detective?
I do.
Your Honor, the prosecution now requests to admit exhibits 1, 2, and 4 into evidence.
Any objection, Mr. Newman?
Yes, Your Honor. I believe that these images are more prejudicial than probative and are being admitted to for the shock value rather than their probative value.
Your Honor, may I respond?
You may.
Your Honor, pursuant to Rule 401, relevant evidence is defined as evidence that tends to prove or disprove a material fact. And pursuant to Rule 402, relevant evidence is admissible. Pursuant to Rule 403, evidence that is more prejudicial than probative is not admissible. This evidence is more probative than prejudicial as it allows the jury to see what the crime scene looked at several different angles and goes directly to the material fact that Mackenzie Brackman was murdered.
All right, objections overruled. Exhibits, what was it, 1, 2, and 4 will be admitted.
Did you see anything else around the body?
I did. The murder weapon was located directly next to him.
And were there photos taken of the murder weapon as well?
Yes.
Your Honor, let the record reflect, I've previously shared exhibit 5 with opposing counsel.
Record will so reflect.
Your Honor, may I share exhibit 5 with the bench and the witness?
You may.
Detective, do you recognize this exhibit?
I do, yes.
And what is it?
This would be the murder weapon as found at the scene of the crime.
And do you use this regularly as a detective?
Yes.
And this is a true and accurate depiction of what you saw at the crime scene.
Correct.
Your Honor, the prosecution now moves to admit exhibit 5 into evidence.
Any objection?
No, Your Honor.
Did you do any further investigation into the house, Detective?
I did, yes. I moved further into the house and into the kitchen and dining room, and I had seen signs of a struggle, like a knocked over chair, a broken plate, and a knife drawer that was slightly ajar.
Objection, Your Honor. Improper lay opinion. He does not have the training or he does not have the qualifications to testify as to what happened at the scene of the crime.
Your Honor, may I respond?
You may.
Your Honor, my witness has been previously admitted as an expert in criminal investigation and homicide investigation. this line of questioning directly goes to the investigation he did into the crime scene, and any opinion based on that evidence is his expert opinion and therefore able to be submitted to the jury.
I'll allow it.
Were you?
Go ahead.
Were you finished answering the question?
Well, broken plate, knocked over chair. There's scuffle marks at the door and the ajar knife drawer. I believe that was it.
And were there photos taken of any of these observations?
Of course.
Your Honor, let the record reflect I've previously shared Exhibit 7 with opposing counsel.
Record will so reflect.
Your Honor, may I share record or Exhibit 7 with the bench and the witness
You
for
may.
identification purposes? Do you recognize this, detective?
I do, yes.
And what is it?
This would be a photo of the knife drawer.
And did you use this photo in your investigation?
I did.
And do you use photos like these regularly in your course of business?
I do.
And is this true and accurate depiction of what you saw at the crime scene?
Yes, it is.
Your Honor, the prosecution now moves to admit Exhibit 7 into evidence.
Any objection, Mr. Newman?
No, Your Honor.
Exhibit 7 will be admitted.
May I publish to the jury?
You may.
Did you do any other investigation at the crime scene?
I did, yes. I had recovered Mr. Breckman's phone.
And did you go through it?
I did.
And what did you learn?
Well, oh, is there an objection?
No, never mind. I had one, but then I realized it was not a solid objection.
Okay, thanks, Mr. Newman. Go ahead and answer the question, Mr. Markowitz.
Sorry, thank you. I had recovered Mr. Breckman's phone and I had gone through his emails and I discovered something called mock trial.
And did you further investigate mock trial after this?
I did, yes. I was able to get in contact with one of his students.
And who was that student?
That would be Alex Cifuentes.
And what did you learn through talking to Alex Cifuentes?
Well, he had pointed me in the direction of Avery Becker, the prime suspect of this case.
Did you ever try to talk to Avery?
I did, yes, but she lawyered up the second I was trying to interview her.
Objection, Your Honor.
What's the objection?
The witness is attempting to a moment to confer with counsel.
Sure.
Your Honor, the witness is attempting to use the defendant's right to remain silent as a lack of trustworthiness.
Your Honor, may I respond?
You may.
Your Honor, I asked the witness whether or not he was able to talk to Avery Becker, and a reason was given for why he couldn't. I don't believe that is prejudicial or more prejudicial than probative in the slightest.
I will allow it.
Thank you, Your Honor. Did you ever further investigate Avery Becker?
Yes, I did. Like I said, she became the prime suspect of the case.
And what did you do to investigate her?
Well, I had gone through the cell tower records for the day of the murder, March 6th.
And did you bring those records here with you today?
I did.
Your Honor, let the record reflect I have previously shared Exhibit 15 with opposing counsel.
The record will so reflect.
Your Honor, may I share Exhibit 15 with the bench and the witness?
You may.
Do you recognize this, detective?
I do, yes.
And what is it?
These would be the cell tower records I obtained on the day of the murder.
And are these the original records?
They are.
Are you the keeper of these records?
I am.
And do you use these in your regular course of business?
I do.
And are these a true and accurate depiction of Avery Becker's cell tower records for March 6th?
Yes, they are.
Your Honor, the prosecution now moves to Exhibit 15 into evidence.
Any objection, Mr. Newman?
No, Your Honor.
Exhibit 15 will be admitted.
Detective, did you ever do a further analysis of this original data?
I did, yes.
And did you bring that analysis with you here today?
I did.
Your Honor, let the record reflect I've previously shared Exhibit 16 with opposing counsel.
Record will so reflect.
Your Honor, may I share Exhibit 16 with the bench and witness?
You may.
Do you recognize this, Detective?
I do.
And what is it?
This would be the analysis I did on the cell tower records.
And this analysis is based on your expert opinion?
Correct.
And you are the keeper of these records?
I am.
And do you use these in your regular course of business?
I do.
Your Honor, the prosecution now moves to admit Exhibit 16 into evidence.
Any objection,
Your Honor.
I'm sorry,
Yes,
what?
I believe this is cumulative evidence, as the previously admitted Exhibit 15 should be sufficient evidence, as this has very little difference to the previously admitted Exhibit 15.
Your Honor, may I respond?
You may.
This evidence is a further analysis of the original data that Detective Jordan Markowitz did in his expert opinion and based on his expert training. And pursuant to Rule 703, any evidence that would otherwise be unadmissible is admissible under an expert's testimony if it helps the jury further understand the facts of the case and they used it in their investigation.
Exhibit 16 will be admitted.
Thank you. May I publish to the jury?
You may.
What does this evidence tell you, Detective?
Well, this evidence shows me the most probable route Avery had taken to Mr. Brackman's house that day.
And this most probable route is based on your expert opinion?
Of course.
And in your expert opinion, what happened when Avery Becker arrived at Mackenzie Brackman's house?
I believe that Avery Becker had broken in an attempt to burglarize and had killed Mr. Brackman.
Objection, Your Honor.
Yes, Mr. Newman.
This is an improper lay opinion. The defense or the witness does not have experience in crime scene reconstruction.
Your Honor, may I respond?
You may.
My witness is an expert, has been admitted as an expert in criminal investigation and homicide investigation. Nowhere in his testimony did he report what the events that happened at the house, but rather, may I rephrase that?
Sure.
My expert is admitted as an expert in criminal investigation and homicide investigation. This is based on his expert opinion of what happened, not the exact events of how Avery broke in and how Mr. Brackman was killed, but what crime happened at the crime scene.
I'll allow it.
Thank you, Your Honor. That will be all for now.
Thank you. Cross, Mr. Newman?
Yes, Your Honor. Today, you testified that cell tower data is like a GPS, correct?
It's incredibly accurate and shows the, as I'd say, a very accurate representation of.
But a single
location.
cell tower can
Your
cover
Honor,
up to 100
objection.
miles, correct?
Putting off my witness.
I'm sorry, what?
Objection, Your Honor. The attorney cut off my witness while he was trying to answer.
Let him answer the question, Mr. Newman.
I Sorry, I thought he finished. If you would like to continue your answer to cell tower, you testified today that cell towers are as accurate as GPS, correct?
Yes, I will say this again. I believe that it's a very accurate way to determine the location of somebody.
Okay, but you do know that cell towers can cover up to 100 miles, don't you?
In total, sure, but as you can see on the exhibit, it's a single cone.
Sure, but that cone can be up to 100 miles in area,
Objection, Your
correct?
Honor, asked and answered.
Overruled. He didn't really answer the question. Go ahead, Mr.
Could you
Newman.
please repeat the question?
Sure, but the cone can cover up to 100 miles, correct?
You're making it sound as if they had gone from 100 miles one direction to 100 the other. I'm fairly sure that they had followed the exact
From
path
the
that I
cell
took.
tower to 100 miles out, that can have the cone can be that size, correct?
I believe it is incredibly unlikely that that is the case, but it could be.
And the call detail records tell you that they could be anywhere in that cone, correct?
It is my professional opinion that they had taken a direct route to Brackman's house, but sure, they could have gone 9 miles, like I said, way over there, to 9 miles, way somewhere else in 2 minutes.
But they could be, a call detail record simply tells you that they are in that cone, not where they are in that cone, correct?
You could say that.
And call detail, and sometimes cell phones do not connect to the closest cell tower, correct?
It is very improbable, but that happens sometimes.
And so is it possible for Avery Becker's phone to be many miles away from Mr. Brackman's house?
No, I do not believe it was possible at all. I believe Avery Becker had gone to Brackman's house at the time of the murder and then had killed Mr. Brackman.
But you just testified that the phone could be anywhere in a extremely large cone, correct?
I do not believe he had gone 9 miles from somewhere to 9 miles somewhere else in a matter of seconds.
The phone could be anywhere in a cone.
Objection,
correct?
Your Honor, asked and answered.
I'll allow it one more time. Answer it if you can, Mr. Markowitz.
Of course.
The phone could be anywhere in that cone, correct?
Yes.
So it is possible that Avery Becker's phone was not anywhere near Mr. Brackman's house, correct?
In the strange hypothetical you're giving me, sure, I guess.
And did you know that screenshots can be easily faked?
Screenshots can be easily faked?
Did you know that screenshots can be easily faked?
I believe that screenshots can be taken. Are you talking about the text messages?
Yes.
I do not believe they were faked.
But is it possible for screenshots to be faked?
Again, you're throwing hypotheticals at me.
Yes. Is it possible for the screenshots to be faked?
Objection, Your Honor, speculation.
Hypothetical questions are allowed with expert witnesses. Answer the question.
Of course. There is I guess, a very, very tiny percent of a chance that this could have happened. But again, it is my professional opinion that those are real text messages taken from Alex Fuentes' phone.
But without Alex Fuentes' phone, you cannot verify who sent the text messages, correct?
I believe it was Avery Becker.
But you cannot verify that.
Objection, Your Honor, the authenticity of the text messages has already been objected to and overruled and determined on.
I'll allow it this cross.
Yes, Your Honor. Thank you.
You cannot verify the sender of the text messages without access to Mrs. Fuentes' phone, correct?
I am incredibly certain that it was Avery Becker, but I guess I can't directly verify from the phone.
Nor can you verify the date and time that the text messages were sent without access to the phone, correct?
I believe they had been 3 months from after the text messages had been sent.
But there are no timestamps in Exhibit 14, correct?
In Exhibit 14, not directly on the phone, but again, I am fairly certain that it was 3 months after the text messages had been sent.
But you can't verify this, can you?
I'm fairly certain that is the case, but again, I guess there's no timestamps on the text messages.
Thank you, Your Honor. No further questions.
Redirect?
Yes, Your Honor, briefly. May I inquire to how much time I have left before I begin?
You may.
You have 2 minutes and 38 seconds.
Thank you. Detective, what is the probability that Avery wasn't at Brackman's house that day on
I
March
believe that
6th?
Avery Becker was 100% at Brackman's house that day. There's no way he couldn't have been.
And what is the probability that the text messages were faked?
0.
And in your expert opinion, who do you think is guilty of the crimes today?
I believe Avery Becker had broken into Mr. Brackman's house and killed him on March 6th.
Thank you. That will be all.
All right, thank you.
Recross, Your Honor?
No recross. Thank you.
Thank you
All
very
right, call your next witness. Prosecution.
The prosecution rests, Your Honor.
Thank you. All right, defendant Maroon team, call your first witness.
Yes, Your Honor. The defense calls Avery Becker to the stand.
All right, where's is it Mr. or Ms. Becker? Who's Ms. Becker? You're Ms. Becker? Okay. Do you swear, raise your right hand, please. Do you swear or affirm under penalty of law that the testimony you're about to give will be the truth?
I do.
Thank you.
Okay. State and spell your full name for the record.
My name is Avery Becker, Becker.
And did you murder Coach Brackman?
No, I certainly did not.
Do you even know where Brackman lives?
I don't.
Okay, so Avery, let's discuss a little bit more about you. Where do you live?
I live in Denver, Colorado.
And where did you go to school last year?
Last year, I was a senior at Colorado High School in Denver.
Were you on any teams or in any clubs at this school?
Yes, I was on the mock trial team for all 4 years of high school.
And why did you decide to join the mock trial team at CHS?
Well, my best friend, Taylor Perkins, and I decided to join the mock trial team together when we were freshmen because we thought it'd be a fun way to get out of the house and spend some time together. And I ended up being really good.
And who was the coach of that mock trial team?
The coach was Mackenzie Brackman.
And how did you feel about Coach Brackman?
I know that many people believe that I hated Coach Brackman, but au contraire, I actually had a great deal of respect for him, and I'm deeply saddened by his death. I wish Brackman had had the same respect for me that I had for him. That was all I ever wanted.
Okay, and how would you be described as a mock trial competitor?
I was really good. I was especially good at cross and closings.
And how did your coach view you as a competitor?
I think Mr. Brackman knew I was good, but he didn't respect my work style. He didn't seem to understand that I could just stand up and do cross on the fly by just listening to the story.
And moving on, did you have any friends on the mock trial team?
Yes, my best friend Taylor Perkins was on the mock trial team with me.
Did you have anyone on the mock trial team you didn't necessarily get along with?
Yes, there's this kid, Alex Fuentes, on the mock trial team, and Alex likes to say that we were best friends, and I don't know why he says that because we never got along. But Alex was very amiable, and maybe that was my mistake. Maybe Brackman would have liked me better if I had been a groupie like Alex.
And would you ever text Alex Fuentes outside a mock trial?
Absolutely not.
Okay, so moving on, can you describe what happened on the day of March 5th, 2020?
Yes. On March 5th, 2020, I went to the Fry Shack with Taylor.
And who did you see at the Fry Shack?
Well, besides Taylor, who I was there with, there were some other people from the mock trial team, including Alex Cifuentes.
And what were you doing at the Fry Shack?
I was playing games on my phone with Taylor and we ate some food.
Okay. And aside from the events of March 5th, 2020, let's talk a little bit about Alex Cifuentes and his life at school from what you observed. Is there anyone in particular you always saw Alex Cifuentes hanging out with?
Yeah, I know Alex is friends with this kid, Blair Rollins.
And can you tell me a little bit about what you know about Blair Rollins?
Yes, I know Blair Rollins is this kid at my high school, and he's approximately the same height and build as I am. And additionally, Blair Rollins' father was convicted on a case that Mackenzie Brackman tried.
And do you know where Blair Rollins is now?
No, I haven't seen him in a very long time.
Okay, so let's talk a little bit about the events following March 5th, 2020. When did you notice your phone was missing? What day?
On the morning of March 6th, I woke up and I couldn't find my phone anywhere. So I guess I had lost it the day before.
And when you found out your phone was missing, what did you do?
I went over to Taylor's house and I told her I couldn't find my phone, and we decided to skip school to look for it.
And where did you and Taylor go for the entire day of March 6th, 2020?
We were trying to retrace my steps of where I'd been the day before, so we went to places where I'd been. First, we went to the mall, and then we went to the Fry Shack.
And were you with Taylor the entire day of March 6th, 2020?
I was.
And were you and Taylor at the mall the entire day of March 6th, 2020?
The mall and the Fry Shack looking for my phone. Yes, we were.
And how did you and Taylor go about looking for your phone?
Well, we were retracing my steps and going to the places where I had been, and Taylor called my phone a bunch of times, and we were trying to see if we could hear it ringing, but we never found it.
And on that day, did your lost phone receive several calls from Taylor's phone?
It did.
No further questions, Your Honor.
Thank you. Cross?
Yes, Your Honor.
Whoops.
Ms. Becker, you're the best attorney, correct?
I am.
And you won Best Attorney Award?
Yes.
You understand the law?
Objection, relevance?
Your Honor, may I respond?
You may.
Pursuant to Rule 611, credibility of witness is always an issue, and this is going to the credibility of Ms. Avery Becker.
I'll allow it.
Thank you, Your Honor. Would you like me to restate the previous question?
Yes, please.
You understand the law?
To the extent of high school mock trial.
And you know what an alibi is?
I do.
And you hated Mackenzie Brackman, correct?
Objection, improper character evidence under Rule 404B.
Overruled.
Would you like me to restate the previous question?
Yes, please.
You hated Mackenzie Brackman, correct?
No, I did not hate him. We got on each other's case sometimes, but I respected him.
Your Honor, may I screen share a copy of the witness's you wrote an affidavit for today's case, correct?
Can you repeat the question?
You wrote an affidavit for today's case, correct?
Can you rephrase the question?
You wrote a testimony for today, correct?
I wrote a witness statement.
Your Honor, may I screen share a copy of the exhibit's witness statement for impeachment purposes?
You may.
Ms. Becker, can you please read line 138?
High school, and Blair is the one person that hated Brackman more than I did.
So in your witness statement, you wrote you hated Mackenzie Brackman, correct?
Objection, improper character evidence. She never said that she directly hated him. She said that she hated him more than somebody else, which can be interpreted in a multifaceted ways.
Overruled.
Mackenzie Brackman rewrote your closings, correct?
Yes, he did.
Direct examinations?
Yes.
Cross examinations?
Objection, relevance. Why is it relevant that he wrote her examinations in mock trial?
Your Honor, this is going to the credibility of the witness once again.
I'll allow it.
And you like to think on your feet, correct?
I do.
And you don't like to use a script?
I don't need to use a script.
And you were upset when Mr. Brackman asked you to use a script, correct?
Yes, I wish he knew that I didn't need to.
And you didn't put in any effort, correct?
I put in exactly as much effort.
Evidence.
I'm sorry, what was your objection?
Sorry, Your Honor, improper character evidence.
Overruled.
You didn't put in any effort to your work, correct?
I put in exactly as much effort as was required for me to win, and I always did.
And Mr. Rackman put you on the B team, correct?
Yes.
And then you convinced Taylor Perkins to quit, correct?
I did not convince nor manipulate Taylor Perkins into quitting. She volunteered to do so herself.
Yes or no? Mr. Rackman had no choice but to put you back on A team, right?
He had no choice. I was the best one, and they couldn't go to regionals with a missing team member.
Thank you. You won awards at regionals, correct?
Yes.
And you deserve them?
I did.
And Brackman didn't think you deserved these, correct?
He didn't.
And he confronted you, correct?
Yes, at practice.
And you got upset with him, correct?
I was angry that he didn't respect me.
So you were on his Porsche, correct?
Yes, and I am very embarrassed to have done that. It was very immature, and I regret it terribly.
But this was no accident, was it?
I meant to use a dry erase marker, and I feel terrible about it, and I would never do anything that would hurt Mr. Brackman.
And you wanted to ride on his Porsche the entire time, correct?
Can you please repeat the question?
You intended to ride on Mr. Brackman's Porsche the entire time, correct?
Objection, improper characterization.
That doesn't go to characterization. Overruled.
Would you like me to restate the last question?
I do not understand the question.
You intended to ride on Mr. Brackman's Porsche with a marker, correct?
Yes, out of anger.
And when Mr. Brackman found out what you did, he kicked you off the team, correct?
Yes.
And you were a senior?
I was.
This would have been your last chance to go to state. Is that true?
Yes.
And in your opinion, you deserve to go to the state tournament?
I knew I would win if I went to state.
So you tried to apologize to Mr. Brackman, correct?
I did.
And he didn't respond to your apologies, correct?
No, and I really wish he had, because I felt so bad about what I had done, and I really wanted to apologize and let him know that I didn't mean to cause any permanent harm and that I was sorry. I wanted him to know that.
Objection under the whole previous line of questioning under Rule 404B, improper character evidence.
Overruled.
Yes or no, you were upset when Mr. Brackman didn't respond to your apologies, correct?
I was sad. I was not angry.
And this made you mad, correct?
No, I was sad.
And you told Alex Fuentes so.
No.
And you told him if you thought what you did to his car was bad, just wait till you see what you did to his house?
I did not say that.
Objection, hearsay.
Your Honor, may I respond?
You may.
Pursuant to Rule 801, hearsay is an out-of-court statement being used to prove the truth matter asserted. But under Rule 801 D2, this is admission by party opponent. It is a statement Avery Becker made herself.
May I respond?
You may.
The exhibits that this attorney is referring to have not been properly authenticated or related to Ms. Becker herself, and have not been related to have been authenticated to actually come from Ms. Becker herself. Therefore, it is hearsay.
Are you admitting the statement for the truth of the matter asserted?
Yes, Your Honor, but under Rule 801 D2, this is still admission by party opponent, and we've already argued the authenticity, and I believe that it's for the jury to decide.
Overruled.
Thank you, Your Honor.
Why don't you re-ask the question?
Yes, ma'am. Ms. Becker, you told Alex Fuentes if you thought what you did to Brackman's car was bad, just wait till he sees what you do to his house, correct?
I did not say that. And Alex Cifuentes is a shameless sycophant who will sacrifice all his values and everything he knows the second he comes into contact with someone who has even an ounce of authority.
Thank you. You were in the courtroom for the entire trial, correct?
Yes.
And you heard Alex Fuentes testify?
I did.
And you heard him testify that you texted him, correct?
I heard that, and I did not text him. I never would text him.
You skipped school the day Brackman was murdered.
I did, to look for my phone. I was with Taylor Perkins the whole day, and she can testify to that.
House, correct?
Can you please repeat the question?
You went to Mr. Brackman's house, correct?
No, I don't know where Mr. Brackman lived, and I never went to his house.
And you tried to get in the front door,
I didn't. I didn't know where he lived and I never went to his house.
but it was locked.
No, I don't know.
So you went around the back of the house.
Objection under Rule 404B in proper character evidence. This has not been proven.
Overruled.
And you opened the door, correct?
I don't know what happened.
You were going to trash his house, yes or no?
I was not.
Just like you told Alex Cifuentes so.
I didn't tell Alex Cifuentes anything, and I never went to Mr. Brackman's house.
Mr. Brackman was home.
I don't know. It is deeply saddening to me to hear the details of his death. I respected him very greatly, and I'm very saddened by his passing.
Mr. Brackman surprised you, correct?
No, I didn't. I never went to his house.
Then you struggled, correct?
No, I never went to his house.
You grabbed a knife?
No.
And you stabbed Mr. Brackman?
I didn't.
And then you ran away?
No.
Thank you, Your Honor. No further questions.
Redirect.
Yes, Your Honor. So, Avery, when you damaged Brackman's car, were you aiming to cause permanent damage?
No, I really thought it was a dry erase marker. We had been in practice and we were about to write things that we had done that were good and bad on the whiteboard. And it was a whiteboard and it was a dry erase marker that I still had in my hand when I stormed out of practice.
And after you damaged Brackman's car, how did you feel?
I felt awful. I went home and I talked to my mom and she helped me calm down. And I realized that what I needed to do was to apologize to Brackman, to show him that I really didn't mean to cause any damage. And I'm so deeply regretful of writing on his car.
And after damaging Brackman's car, did you try to make up with him?
I did. I went to his office and I spoke to his secretary and I asked her if I could speak to Mr. Brackman, but he didn't want to talk to me. And then I texted him and he just ignored me. And I'm really sad that I wasn't able to apologize or to have him accept my apology.
And do you even know where Brackman lives?
I have no idea where Brackman lives. And if I did, I wouldn't go there because he was so angry about what I had done to his car that he would have pressed charges if he saw me.
And did you ever do anything to Brackman besides accidentally writing on his car in permanent marker?
No, and I never would. I really respected Brackman and he was a good coach and he figured out how to get us to a place where we were competitive. And I would never do anything to hurt him.
No further questions, Your Honor.
Thank you. Defendant, call your next witness.
Your Honor, the defense calls Taylor Perkins to stand.
Okay. Ms. Perkins, will you raise your right hand? Do you swear or affirm under penalty of law that the testimony you're about to give will be the truth?
Yes, Your Honor.
Very good. Go ahead, Mr. Pumelli.
Thank you, Your Honor. Please state your name and spell your last for the record.
Taylor Perkins, Perkins.
Do you know why you are here to testify today?
I do, yes. My best friend Avery Becker has been wrongly accused of murder. However, she couldn't have murdered Mr. Brackman because she was with me all day, March 6, 2020.
Whoa, okay, let's back it up a little bit. Where do you currently reside?
I'm currently in Boulder, Colorado, as I'm a freshman at CU Boulder.
Does that mean you were in high school last year?
I was, yes. I was a senior at Colorado High School, more commonly known as CHS.
And at CHS, were you involved in any extracurricular activities?
I was, yes. I was on the mock trial team with my best friend Avery Becker.
And who was your coach on that team?
Our coach was a criminal defense lawyer named Mackenzie Brackman, who personally was pretty mediocre.
Did you have the opportunity to observe Avery perform on the mock trial team?
I did, yes, both at practices and at tournaments.
How was Avery's performance in mock trial?
But it was very clear that Avery was the best player on the team, not that Mr. Brackman would admit that.
Did you have the opportunity to observe Coach Brackman's reactions to Avery when she came to practice late or unprepared?
I did, yes. More times than not, he would get very mad. You could almost see the steam coming out of his ears.
Let's turn to a month before the regional tournament last year. Did you observe Avery at mock trial practice?
I did, yes. She came to practice most unprepared I've ever seen her, making things up on the fly and getting a little bit off track, but still performing well.
And what, if anything, did Coach Brackman do to Avery as always? Sorry. What, if anything, did Avery do to let me rephrase the question. What, if anything, did Coach Brackman do to Avery as a result?
Well, surprise, surprise, Mr. Brackman was very mad and decided to demote Avery down to B team, which was totally unfair.
What do you mean by B team?
On the mock trial team, there were two teams, the B team for the better players and the B team for the not so good players.
What did you do, if anything, after Avery was demoted?
Well, I didn't really want to be on the mock trial team if my best friend wasn't on there with me. And I didn't want to be a lawyer, so I decided to step down from the team, giving Mr. Brackman no choice but to put Avery back onto the A team.
Did Avery tell you about the incident at the mock trial practice where she wrote on Coach Brackman's car with a marker?
She did, yeah. She talked to me that night.
What, if anything, did Avery tell you about the marker she used?
She specifically told me that it was a dry erase marker. Of course, we both later found out it was a permanent marker, but it was an honest mistake.
Do you know Alex Fuentes?
I do, yes. She went to my high school and was on my mock trial team with me.
Did you have the opportunity to observe Avery interact with Alex?
Yes, I did.
Did they appear to you to be friends?
I mean, maybe on the surface they were okay, but they really didn't get along.
I want to turn to Thursday, March 5th, 2020. Did you see Avery that day?
I did, yes. She came by my house and we played some games on our phones for a while.
What did you do later that evening?
Well, we were sort of hungry, so we decided to go to the fry shack to get something to eat, which actually turned out to be kind of a bad idea.
And why was that a bad idea?
Well, while we were still eating, some of the members of the mock trial team came in.
Interesting. And was Alex Fuentes there?
Yes, he was. She was.
At some point, were the mock trial kids talking to Avery?
Yes, they were. They kept going on and on about how unfair it was that Avery was kicked off the team.
How did Avery respond to what they were saying?
Well, obviously, Avery got really upset and kind of stormed off to the bathroom, even leaving her phone at the table.
Your Honor, objection, hearsay.
Any response?
I'm not asking for her to say what they said, so no out-of-court statements are being offered.
Your Honor, I stand by my objection.
Right. Well, repeat the question, Mr. Palali.
How did Avery respond to what they were saying?
Well, you're asking for a response. What she said, or are you asking her to describe her demeanor?
I'm asking her to describe her demeanor, her actions that she took after.
All right, the hearsay objection is sustained as to any statements that she may have made.
Thank you, Your Honor. What, if anything, did you notice when Avery went to the bathroom?
I noticed her phone was still on the table, which really surprised me since that thing was like a third kidney to her.
Who, if anyone, stayed at the table when Avery went to the bathroom?
Alex Fuentes stayed at the table and kept talking to me about how unfair it was Avery was kicked off the team. I wanted to punch him.
And what happened next?
Next, Avery came back to the table and we decided to head out for a while.
Did you notice anything about Avery's phone when you left the fry shack?
I think it was still on the table, but I'm not 100% sure.
And where did you go next?
Next, we went to the malls. That was right before they shut down and life was so much different.
Let's turn to the morning of March 6th, 2020. Did you see Avery that day?
I did, yes. She came by my house to pick me up for school like she typically does.
And what, if anything, did you find out when Avery came to get you?
Well, the previous night or this morning, Avery hadn't been answering any of my texts or calls, and that was pretty weird. So I asked her about it, and that's when we both realized that her phone was missing.
So what did you do next?
Well, we'd already taken an English quiz earlier in the week, and our classes were so dry that day. So we decided to ditch school and look for the phone.
And where did you go to look for the phone?
We went to the mall first, and we looked in every single store that we had gone into the previous day.
Did you find the phone at the mall?
No, we didn't. We spent the entire day looking for it with no outcome.
Did you go anywhere else?
I did, yes. I remembered seeing the phone at the fry shack the night before. So we went there to check with the afternoon staff.
And did you find the phone at the fry shack?
No, unfortunately, we didn't.
were you with Avery Becker all day on March 6th, 2020?
I was, yes, and the police are welcome to track my phone, which by the way, they never did.
Did you and Avery ever go near Coach Brackman's house on March 6th, 2020?
No, of course not. I don't even know where Mr. Brackman lives, and I'm really sorry that he's dead, but it wasn't Avery.
Thank you. No further questions, Your Honor.
Cross, Ms. Gonzalez?
Yes, Your Honor. May I begin?
You may.
Ms. Perkins, you and Avery were best friends, correct?
That is correct, yes.
You would do anything for Avery Becker, correct?
Just about everything.
And Avery's relationship with Mr. Brackman was no good, yes or no?
No, Avery was pretty underappreciated by Mr. Brackman.
And you would say that Avery's relationship with Mr. Brackman was no good because she never put effort into mock trial?
I would say that it wasn't good because Mr. Brackman got mad when Avery was unprepared. So yeah.
So Avery never came prepared, correct?
Sometimes she would come unprepared, but it wasn't all the time.
And Avery didn't try hard enough, yes or no?
She did. She
Objection,
tried
Your Honor.
after.
Yes, hang on. Just a moment, Ms. Perkins. Mr. Pumali, what's your objection?
Argumentative.
Overruled. Go ahead, Ms. Gonzalez.
Would you like me to restate that question, Ms. Perkins?
Yes, please.
And you believe that Avery didn't try hard enough?
I wouldn't say that she didn't try hard enough. She really cared about mock trial. She just came unprepared sometimes.
Would you say that Avery was the best attorney in mock trial?
Yes, it was very clear that Avery was the best attorney on the team.
And both you and Avery agreed that Mr. Brackman was a mediocre coach, correct?
Yeah, pretty mediocre coach, personally, if you ask me.
In fact, Avery even played some games or some pranks on Mr. Brackman, correct?
That is correct, but she never played the pranks on him to hurt him in any serious way.
Now let's talk about the regional tournament. During the regional tournament, Avery came unprepared, correct?
Yes, she did, but still won some awards.
And Mr. Brackman, as the coach of the mock trial team, demoted her to B team, correct?
Yes, he did, which was totally unfair.
So because of this, you quit mock trial, is that correct?
I did, yes. I really didn't want to be a lawyer, and I didn't want to be on the team unless my best friend was on there.
So you did this so Avery could be moved back up to A team, correct?
That is correct. Like I stated before, it meant more to Avery than it did to me, and I didn't really want to be on there anyways.
So Mr. Brackman then had no choice but to move Avery back up to A team, yes or no?
That is correct, where she rightfully belonged.
But you were a good attorney too, correct?
I would say I was pretty good, yeah.
And Coach Brackman oftentimes called out Avery on her bad workmanship, is this correct?
Typically he would just get mad if she was unprepared, but she never did poorly.
But Mr. Brackman, as the coach, knew what was best for mock trial, correct?
Yes, he probably did, but like I said before, he wasn't a great coach, so.
So let's move on now. Avery wrote on Mr. Brackman's vintage Porsche with a permanent marker, yes or no?
Yes, but on accident.
So Avery just wanted to blow off some steam?
That is correct. She had a little bit of a temper, but didn't want to cause permanent damage and felt really bad.
So after this, Avery got kicked off the mock trial team, correct?
That is correct, yes.
So Avery was upset because of this?
She was, yes, at first, but then she realized that she had made a mistake and wanted to apologize.
So Avery was desperate to be back on the mock trial team, correct?
I wouldn't say desperate. She just really wanted to apologize.
And Avery even went as far as to go to a mock trial practice to beg Mr. Brackman back on the team, correct?
Yes, she did. She really felt bad and wanted his forgiveness.
So after this, you and Avery went over to the fry shack, am I correct?
That is correct, yeah.
And did you happen to bump into the mock trial team there?
We did, yes. We saw some of the team members there.
And was Alex Cifuentes one of those team members?
Yes, she was.
And Avery didn't like Alex, correct?
No, they really didn't get along.
Yet she even asked Alex Cifuentes for help back on the mock trial team?
Objection, Your Honor. The question
What's
goes for hearsay.
Your Honor, may I respond?
You may.
Pursuant to Rule 701, a lay witness may testify based on their rational perception. Taylor Perkins stated this in her affidavit, and I am simply asking her some questions to lead up to.
I'll allow it.
Ms. Perkins, should I restate my question?
Yes, please.
So Avery even asked Alex Cifuentes for help?
I think that she contacted every person on the team, but I'm positive.
So Avery texted Alex Cifuentes, correct?
I'm not positive if she did or not. I think she did though.
So Avery then claimed to have lost her phone at the fry shack?
Either at the fry shack or at the mall, sometime that evening.
But you said that this phone was like a third kidney to Avery?
That is correct, and that shows you how upset Alex made Avery to make her forget her phone.
Yeah, it took you all night and even the next morning to realize that her phone was missing? Is this correct?
That is correct, once again showing how much stress Alex caused.
Ms. Perkins, you weren't with Avery on March 6th, correct?
I was with Avery all day on March 6th.
You don't know where Avery was on March 6th, correct?
I do, in fact, know where Avery was on March 6th all day.
Avery broke into Mr. Brackman's house that day. Is this correct?
That is not correct at all. She was with me the entire day.
Avery killed Mr. Brackman, correct?
That is not correct. We were looking for the phone all day and we were nowhere near Mr. Brackman's house.
And you would do anything for your best friend Avery, so you covered for her, correct?
That is not correct. Avery is my best friend, but I would never lie when somebody's life is at stake.
Your Honor, that is all. Thank you.
Redirect.
Yes, Your Honor. May I proceed?
You may.
Ms. Perkins, how would you describe Avery's personality?
Avery was pretty playful and open and had a lot of fun.
All right, thank you. No further questions.
All right. Call your next witness.
Your Honor, the defense calls Professor Blake Van Owen.
All right. Professor Van Owen, will you raise your right hand? Do you swear or affirm under penalty of law that the testimony you're about to give will be the truth?
I do.
Thank you. Go ahead, Mr. Newman.
All right. Professor Van Owen, please state your name and spell your last.
Blake Van Owen, VAN space OWEN, and I prefer Professor Van Owen.
And what is your experience with police work?
I worked for the Aurora Police Department for a period of 9 months between 2005 and 2006.
And after leaving the Aurora Police Department, did you do any continuing education?
Yes, I got my master's degree in criminal justice from the Ashford University's online program.
And where do you work now?
I teach a class at CU Denver on social justice and police practices.
And do you do any other work?
I work as a private investigator.
And have you ever been qualified as an expert before?
Yes, I have. I've been qualified as an expert witness in over 100 cases.
Your Honor, we would like to qualify Professor Van Owen as an expert witness under Rule 702 as in the fields of crime scene reconstruction, call detail records, forensic data recovery, police practices, and investigation.
Any objection, Ms. Rubio?
Yes, Your Honor, I object to lack of foundation of crime scene reconstruction. I don't believe I heard any foundation laid for that expertise.
I can lay some more foundation for crime scene reconstruction if that would be
Yes, please do.
if that would be helpful.
Yes, it would be.
All right. So during your experience or during your work, what sorts of things do you generally do for your clients as a private investigator?
I investigate into the cases as much as I can, and I have even been qualified as an expert in crime scene reconstruction 8 times.
All right. Now we would like to again request to qualify Professor Van Allen as an expert under Rule 702 in crime scene reconstruction, called detail records, forensic data recovery, police practices, and investigation.
Any objection?
Could you say that again? I
Sure.
didn't-
Crime scene reconstruction, call detail records, forensic data recovery, police practices, and general investigation.
Yes, Your Honor, I object to the call detail record analysis and the forensic data analysis. There was no foundation laid for those either.
I'll allow her to testify as an expert.
Yes, Your Honor.
And what in this case did you review, Professor Van Allen?
I reviewed the police reports, the crime scene reconstruction conducted by Kyle Kuzak, as well as the cell tower analysis and exhibits prepared by Detective Markowitz.
In your expert opinion, how do you feel the investigators did?
They definitely rushed this investigation and went with the easy route. They cut corners, rushed, and
Objection, speculation. She was not involved with the investigation. She conducted her own partial investigation and only reviewed the work that was done.
He is giving her an expert opinion based on the materials that have been prepared and based on the materials that have been prepared and also the research and investigation that she has done herself.
I'll allow it. She reviewed their investigation.
Thank you, Your Honor.
And how do you feel about this rushed, easy conclusion?
would you like me to continue my response from the earlier?
Yes. Yes.
Okay. They missed key facts because of coming to an easy conclusion, and this conclusion left significant doubt as to who actually committed the crime.
And how do you think they came to this conclusion?
I believe that Detective Markowitz suggested Avery Becker as a suspect to Kyle Kuzak, and from there on out, Kuzak's analysis was colored. And all he needed to do was find facts and information that would support that, rather than find all possible evidence before coming up with a conclusion.
And is there a major piece of or what support is there for Kuzak's opinion of a struggle?
There is none.
The prosecution did use scuff marks as evidence. Why do those not assist in correctly determining who did the crime?
Scuff marks are totally irrelevant. There's no way of carbon dating scuff marks, so we have no clue when they were made. They could have been made 5 years ago for all we know.
Is there any other major pieces of evidence that you found to be inconclusive?
Yes, the theory that the knife came from, or the murder weapon came from the knife block in the kitchen. That knife is not the same style, brand, and it doesn't even have the same blade dimensions as all of the other knives in the otherwise uniform knife block. It's ridiculous.
Your Honor, permission to share was previously marked as Exhibit 21.
All right.
And what is Exhibit 21?
That is a picture of me holding a knife and it showing an alternate way of holding the knife.
And does this knife have a very similar, roughly the same handle shape and handle ergonomics to the knife used in the murder?
Yes, it does.
And is this a fair and accurate representation of the way you believe the knife was held during the murder?
Yes, it is.
Your Honor, permission to admit what was previously marked as Exhibit 21 and
Any
publish it to
objection?
the jury.
Sure. Any objection?
No, Your Honor.
All right. You may publish, Mr. Newman.
Thank you. And how do you feel that this would have changed if you had how do you feel that this would have changed the way the prosecution thought about the case if this had been taken into account?
Well, if the knife were held this way, it would support the theory that the intruder was standing over Brackman, who was sitting down.
And the detectives say that Mr. Brackman could not have been sitting down because of the Ring doorbell and notifications. Do you have any experience with the Ring doorbell system?
Yes, I do. I have a setup myself, and you can easily turn off notifications or miss the notifications entirely.
And now on to Detective Markowitz. Did he miss anything important?
Anything? He missed many things. He decided it wasn't important to gather the complete user records for the Ring app, so we don't know if the notifications were even on at all. And then on top of that, he only got cell tower records for Avery Becker for a limited amount of space and time, which, oh boy, there are some red flags in that one. A detective who had not already made their mind up would have perhaps gotten all the numbers in the area at the time of the murder and then found any with correlation or a connection to the victim. But instead, we only have the records for one person. And even if getting all the records was too much work for this detective, he could have at least gotten the records for Taylor.
Objection, Your Honor, narrative.
Yeah, break it up.
Okay. Is there, so should we just stop with what we've had said so far, or should I
No, you don't have to go back. You don't have to go back.
Was there anybody's phone that the detective should have checked?
At the very least, you should have checked Taylor Perkins' phone to confirm that Taylor Perkins was where they said they were.
And was there any other instances of mismanagement of the case?
Yes, accepting screenshots as evidence is totally unreliable.
And was anything important potentially lost?
Yes, apparently photos of blood were lost. I mean, this is why we make backups. It's not rocket science.
And can screenshots be faked?
Easily.
And what do, at the very most, the cell tower records show?
At the very most, that Avery Becker's phone connected to a cell tower near Brackman's house at the time of the murder.
And why does this not even show that much?
Because in urban settings, cell towers can cover up to a 6 to 7 mile radius, and phones don't always even connect to the nearest cell tower. They only connect to the one with the best connection.
But what do the records support?
They do support that Avery Becker and Taylor Perkins were looking for the phone at the time of the murder because there are outgoing calls from Taylor Perkins' phone to support them trying to call it to find it.
Did you find any other suspects in your investigation that you believe the detectives missed?
Yes, I found one with far more motive than getting kicked off of a mock trial team, Blair Rowlands.
And what evidence did you find to support that?
Well,
Objection, Your Honor, relevance.
Your Honor, this is relevant as we are trying to determine who killed Mackenzie Brackman in this case, and this is directly consequential to finding out who killed Mackenzie Brackman.
Your Honor, may I respond?
Briefly.
Your Honor, pursuant to Rule 401, relevant evidence is defined as evidence that tends to prove or disprove a material fact. The material fact in this case is whether or not Avery Becker should be charged with second-degree burglary of a dwelling and/or first-degree murder. Blair Rowlands plays no part in either of those charges.
Well, it's an alternate suspect. I'm going to allow it.
Thank you, Your Honor.
And so what evidence did you find to support this?
Well, Blair Rowlands was also missing from CHS on the day of the murder.
And do the call detail records support this theory?
Yes, the route that Avery would have taken from her house to Brackman's house is the same that Blair would have taken.
Your Honor, permission to share was previously marked as Exhibit 22.
You may.
Thank you. And what is Exhibit 22?
It is a recording from the sentencing of Jonathan Rowlands during his trial. Jonathan Rowlands is Blair Rowlands' father.
And what happened at Jonathan Rowland's trial?
Brackman had represented Jonathan Rollins, but failed to get him acquitted of the charges.
And what were the charges?
I believe it was murder.
Your Honor, permission to, and what is this a recording of?
It is a recording from the sentencing of Jonathan Rollins' trial.
And this is a fair and accurate representation of of what happened at the sentencing of Jonathan Rowland's trial, as far as you have been able to find out.
Yes, it is.
Permission to admit what is previously marked as Exhibit 22 and publish it to the jury.
Any objection, Ms. Rubio?
Yes, Your Honor. I object to relevance, and this evidence is more prejudicial than probative.
May I respond?
You may.
This is very relevant, as it is part of the defense's theory of the case, and in addition, it is to reinforce the additional suspect of Blair Rollins. And this has probative value that outweighs its prejudicial value, because the jury needs to know the motive would assist the jury in finding out who has committed this crime, and I believe this would help shed light on a potential motive for Blair Rollins.
Your Honor, may I respond?
Briefly.
Your Honor, this is a recording of Jonathan Rollins, not Blair Rollins. While I acknowledge Blair Rollins as a possible suspect, Jonathan Rollins plays no part and is currently in jail. It was he who made this threat, not his son.
I'll allow it.
Thank you.
Go to the weight.
I'll get you back, Brackman, if it's the last thing I do. I'll get you back.
All right. And then, was there anything else that was similar between Rollins and Becker?
Yes, they both went to CHS, and they both had a similar height and build as we've seen from yearbook photos, and both Taylor Perkins and Avery Becker said so.
And is there any other important facts that might have been missed?
Yes, I have found that Alex Cifuentes and Blair Rollins were both friends.
Thank you, Your Honor. No further questions.
Cross?
Yes, Your Honor. Good morning, Ms. Van Owen. You have become disillusioned with the justice system. That is correct.
Yes.
And that is why you quit the Aurora Police Department, correct?
Yes, I did not believe with some of their tactics, or agree with some of their tactics.
And this is because of when you injured a young woman of color during an arrest, correct?
Yes, it is.
And this is why you only testify for the defense, correct?
No, it's not. I only ever get hired by the defense because the other side.
But you only testify for the defense, correct?
That is correct.
And you make
not only because of that incident.
Excuse me, Ms. Van Owen. And you make $6,000 to $10,000 off of each case. That is correct?
Objection, relevance?
Goes to bias.
Why does it matter how much the witness is being paid to appear here?
Your Honor, may I respond?
No, not necessary. Overruled. Goes to bias.
And you make $6,000 to $10,000 per case. That is correct, Ms. Van Owen?
Yes, I do. It's my job.
And you make a decent living off of this work, correct?
Yes, we all need jobs.
So you benefit from testifying against the prosecution then, that is correct?
I benefit from testifying because I am getting paid to, because it is my job.
In your direct, you reference Taylor Perkins. She is the only alibi that Avery Becker has in today's case, correct?
Yes, Taylor Perkins is Avery Becker's alibi.
And both teenagers were absent on March 6, 2020, correct?
Yes.
And you didn't obtain any security footage that confirms they were looking for Avery Becker's phone? Yes or no, please?
I did not.
And you didn't obtain Taylor Perkins' cell tower records? Yes or no, please?
I did not, but I'm not the one trying to.
And you didn't confirm Taylor Perkins' alibi? Yes or no, please?
Could you please repeat that question?
You didn't confirm Taylor Perkins' alibi? Yes or no, please?
No, I did not.
And you don't have any physical evidence that confirms Avery's alibi, yes or no? Please.
I do not.
You don't have any physical evidence that confirms Avery was with Taylor Perkins on March 6, 2020, yes or no, please?
Avery Becker and Taylor Perkins have said they were together, and I believe that is evidence enough.
You believe that the police came to an easy conclusion?
Yeah, I do.
And that their evidence shows they don't investigate this case?
Could you please repeat the question?
And that their evidence shows that they really didn't investigate this case?
They did investigate the case, but not thoroughly enough.
And in your direct, you mentioned that you conducted a partial investigation. To do this investigation, you reviewed the reports and exhibits prepared by the prosecution experts?
Yes, I did.
And your investigation is purely based on evidence from the prosecution?
Not only, as you said and I have said, I did my own partial investigation.
And your investigation is purely based on conclusions from the prosecution, yes or no, please?
No, it is not, because I did my own partial investigation and it is not completely based on that.
Thank you, Your Honor. That will be all.
Redirect?
Yes, Your Honor. Why didn't you investigate Taylor Perkins' phone?
Because I'm not the one trying to disprove Taylor Perkins. To me, her testimony is enough.
But do you think that the people who are trying to disprove Taylor Perkins should have investigated her story?
Most definitely, especially if they have the burden of proof beyond an unreasonable doubt.
Thank you, Your Honor. No further questions.
Very good. Thank you, Ms. Van Oden. All right. We will start with closing arguments. Ms. Rubio, are you ready?
Yes, I am, Your Honor.
All right, you may proceed whenever you're ready.
The prosecution asks that any remaining time be saved for rebuttal.
Okay. Why don't you mean after you give your closing?
Yes, Your Honor.
Okay. And we'll verify how much time that is.
Thank you.
Okay. All right. Go ahead.
In the words of Juvenal, revenge is always the weak pleasure of a little and narrow mind. The evidence presented to you today and the witnesses' testimonies have proven beyond a reasonable doubt that Avery Becker is guilty. This is the result of their anger that's been developing for years. Today, Avery Becker, the defendant, is being charged with murder in the first degree and second-degree burglary of a dwelling. What does this mean for you, the jury? This means that Avery Becker intentionally and unlawfully broke into Mackenzie Brackman's house with the intent to vandalize his house, and in the process of committing this crime, killed Mackenzie Brackman. Avery Becker had just been permanently kicked off the mock trial team and believed Mackenzie Brackman had ended their mock trial career. She had exhausted every resource that they had at their disposal to get back on the team, even trying to confront Mr. Brackman at a mock trial meeting where she wasn't wanted. Avery Becker even texted Alex Fuentes and pleaded with her to help them. When all of this didn't work, Avery snapped and planned on going to Mackenzie Brackman's house to trash the place. In Exhibit 14, you heard Avery admit to planning this. Avery Becker had the means and opportunity to commit this crime. These crimes. The intruder, Avery, chose a time of day when Mackenzie Brackman would normally be out of the house. This is knowledge that Avery had and used. In addition to the motive, means, and opportunity that Avery Becker had, we also have a timeline that fits both the crime and Avery Becker's schedule on March 6th. We know for a fact that Avery Becker was absent from school and was marked absent on March 6th. And other than Taylor Perkins' word, Avery has no alibi for the entire day. You heard Taylor. She is biased and she lied. We have proof that Avery Becker's phone was at Mackenzie Brackman's house. We know this due to Detective Jordan's testimony and exhibits 15 and 16. Avery Becker is not the sort of person to let their phone out of their sight. And even if they did, they wouldn't wait an entire day before going to find it. This is shown and proven when Taylor calls the phone their third kidney. It is not a coincidence that Avery Becker has reported their phone missing. This is a deliberate act by Avery Becker to create doubt about their act of revenge. We, the prosecution, have the burden of proof, and we have proven beyond a reasonable doubt that on March 6, 2020, in Denver County, Avery Becker knowingly and unlawfully entered Mackenzie Brackman's dwelling with the objective to commit second-degree burglary and, in the course of action, caused the death of Mackenzie Brackman. As you deliberate, I ask that you remember Avery Becker has experience in a courtroom and with criminal law. Avery Becker knows how to manipulate the legal system. You, as the jury, have the right to believe all, some, or none of a witness's testimony. When the judge reads you the law, they will explain direct evidence and circumstantial evidence are given the same weight in the court of law, and both are acceptable. The prosecution asks that as you deliberate, you apply the law to the facts and deliver a verdict saying Avery Becker is guilty of second-degree burglary of a dwelling and murder in the first degree. Thank you.
Thank you. Timekeeper for the Castle team, how much rebuttal time will Ms. Rubio have?
She has 53 seconds.
53 seconds? Thank you. Okay, now I believe, Ms. Geiger, are you doing closing?
Yes, Your Honor.
All right, you may begin whenever you're ready.
May it please the court, this case comes down to a simple conclusion. The prosecution was rushing to get this case wrong. From the beginning, the investigation of this case was rushed, and several key pieces of evidence went mysteriously missing without further investigation. Why? Because they were rushing to charge my completely innocent client, Avery Becker, with a falsely accused murder. This all circulates back to a key point in this case. The prosecution was unable to present evidence that would prove beyond a reasonable doubt that my client has committed the crime she stands on trial for today. Now, let me remind you, we as a defense do not have the burden of proof in this case, but nonetheless, my team and I were able to prove that Avery Becker was not responsible for the murder of Mackenzie Brackman. In their investigation to get this case wrong, the prosecution heavily relied on evidence they received from their expert witness, Jordan Markowitz. However, they failed to investigate the shortcomings in their case that Jordan Markowitz left. The prosecution relied heavily on evidence from cell towers, in which Markowitz is an expert on, failing to mention that Markowitz received only a short education of 3 days to get a certificate in phone technology. Additionally, the investigation by Markowitz into Avery Becker's cell phone tower records proves Avery's statement that her phone was lost, proving that the evidence of the cell towers connected to Becker's phone were an inaccurate depiction of the real location of Becker, and additionally provides evidence that once again, Avery was not at Mackenzie Brackman's house at the time of his murder. Furthermore, the prosecution failed to realize the significance in the corruption of photos, which proves the carelessness taken in this investigation and the lackluster investigation carried out by Jordan Markowitz, who conveniently lost key pieces of evidence in an important murder investigation, proving a lack of thought and attention put in by the prosecution as they carried out their investigation, rushing to get this case wrong. Kyle Kuzak, a forensic reconstructioner, rushed through their investigation of this case, in which Kuzak relied on photos of the crime scene that were conveniently corrupted, and furthermore, failed to do further investigation by not recovering any DNA in their investigation of the crime scene, providing a lack of evidence for the prosecution, and again, making them unable to prove beyond a reasonable doubt Avery Becker was there at the time of Mackenzie Brackman's murder, and calling into question the credibility of this witness who seemingly didn't care enough to collect crucial pieces of evidence, rushing to a wrong conclusion of this case. Alex Cifuentes provides a statement full of disinformation and lack of evidence. Cifuentes conveniently forgot to bring their phone into the police station, a phone they claimed had text from Becker, saying she was going to Mackenzie Brackman's house to commit the murder that day, when in reality, Avery didn't even know where Mackenzie Brackman lived. Alex's statement furthermore disproves the validity and truthfulness of this witness for the prosecution. When in a world of easy photoshopping, the texts presented in Exhibit 14 are not reliable and makes for an untrustworthy witness on the side of the prosecution, as they were once again rushing to get this case wrong. Today, the prosecution has presented a case with unreliable witnesses and lackluster evidence. I now want to point your attention to the jury instructions presented on page 6 of the official case problem, and in particular, jury instruction number 2. Jury instruction number 2 states that the prosecution must prove beyond a reasonable doubt, based upon presentation of evidence and solely facts, that the defendant, Avery Becker, was guilty. It additionally asks you to look at the presentation of evidence and base your opinion of the case after the evidence or lack of evidence that was presented on the side of the prosecution. However, with the presentation of vague and even speculative assertions, the prosecution has failed to present enough evidence today that would prove beyond a reasonable doubt that my client, Avery Becker, is guilty. In the end, we ask you to look at the argument presented by the prosecution as what it is: incomplete and full of holes, as they rush to get this case wrong and falsely accuse Avery Becker of committing a murder in which they have no real evidence to prove beyond a reasonable doubt that Avery Becker was even at or near Mackenzie Brackman's house on the day of his murder. In this case, even though the defense is not responsible for the burden of proof, my team and I have been able to show evidence for both an alibi and an alternate suspect for the murder of Mackenzie Brackman, showing that Avery Becker is not responsible for the murder of Mackenzie Brackman. We ask you to return a verdict of not guilty. Thank you.
Thank you. Rebuttal?
Yes, Your Honor. May I inquire how much time I have left?
Sure. I think you have 53 seconds, she said. Do you want to
Right.
verify that?
Sorry, you have 53 seconds left.
Thank you. Ladies and gentlemen of the jury, what you have heard from the defense is an attack on the investigation of the prosecution. What you didn't hear or see was evidence that could convince you that Avery Becker didn't commit these crimes. And if we want to talk about credibility, we talk about an expert who only testifies for the defense. Taylor Perkins, the best friend of the defendant, and then the defendant herself. We have proven beyond a reasonable doubt that with credible evidence and expert testimonies that Avery Becker is guilty. And we ask that you return a verdict of guilty in turn. Thank you.
Thank you. That concludes the evidence, ladies and gentlemen. Mr. Hershey, Ms. Starrett, and Mr. Rooney, if you'll finalize your scoring sheets and let me know when you're done, I'm going to give you each 4 minutes to critique or praise the participants. So let me know when you're done.
I think mine are good to go.
Good to go?
Yep.
Me too, Judge.
That's a nice flag, Tony.
Yeah, thank you. It's my little screen background.
Ms. Starrett, are you done?
Yeah, I'm done.
Okay, how about you, Mr. Rooney?
It looks like my internet might be a little slow. It's saying error processing entry, but I will retry to insert my scores again.
Okay. While he's doing that, why don't we start with you, Ms. Starrett? Do you have any comments for the participants?
I think, first of all, you guys all did really good. I did mock trial for all 4 years of high school, so I know how nerve-wracking it can be, and I thought you all did really well. Mr. Newman, I actually really liked, there was one point where you were about to make an objection, but then you stopped and retracted it, and I actually really liked that because I think a lot of the times objecting to just object kind of takes away from like the storyline and it gets kind of confusing. So I think the fact that you kind of noticed that made you stand out more to me, at least. I really liked that.
Thank you. You done, Ms. Starrett?
Yes. Overall, good job, guys.
Mr. Hershey.
Excellent round. I hadn't heard this case yet. I certainly like the facts. Really entertaining case. Really good job on both teams. Witnesses were great. Tyler, you were excellent. The professor who now I forget on the defense side, I forgot her name just briefly, but excellent. Kiara, thank you. Excellent job by all the witnesses. Lawyers, Dylan, I really liked your opening. Very good job. And the closing by both the people and the defense. I mean, this is the time, you know, to sum up the facts, you know, really lay it home to the jury. And you both are great. You know, you're listening clearly during your case. I know that mock trial is a little scripted, but you guys are listening, and both teams did a really good job hitting home on those facts in the closing. So excellent job. I really enjoyed judging this round. Thank you guys so much.
All right, Mr. Rooney, I just got a email from Lance that said he doesn't have your timesheets. Were you able to send them?
I am working on retyping them in right now.
Oh, you have to retype them all?
Yeah, it looks like there was some sort of error on my end.
Okay. Well, why don't you take a minute and do that?
Sure.
I don't want to adjourn until Lance has all the score sheets.
Sure. Be fast here.
Well, I thought everybody did a great job. I always enjoy judging these mock trial competitions every year. Everybody was very poised. Ms. Pearson, you had a really good response. You were really prepared for objections. I thought you had very good responses whenever an objection was made. Mr. Newman, I liked your objection on the photos, the gory photos. You know they're always coming in, but I thought you had a good argument against why they were prejudicial. Mr. Rubio, you did a good job responding to objections as well. I just think all in all, everybody was very prepared. You guys did a great job. Wish you the best of luck for the rest of the competition. Are you guys done today or tomorrow?
Today,
We're done today.
You're done today? And if you go to state, is state going to be via Zoom as well?
We believe so, yes.
Yeah. Well, I think you guys did a good job. It's not hard doing all this stuff via Zoom. I haven't tried a jury trial since last March. Everything is done. All my hearings and trials, civil trials, are being done via WebEx, which is similar to Zoom, and it certainly makes trials a lot more difficult. Sometimes you can't hear the witnesses. It makes using exhibits really difficult, and you guys all did a great job with the exhibits via technology.
Judge Lynch, I thought this went really well with Zoom. Do you foresee a future where maybe a jury trial or maybe a court trial could be done by Zoom or by WebEx?
Yeah, I mean, I do bench trials
Oh, okay.
via WebEx all the time. And all my divorce trials are via WebEx. But I'm looking forward to getting back to seeing human beings in real life. You good, Mr. Rooney?
I think so. Hopefully my scores went through to.
Okay, you want me to text Lance?
Yes, please. That'd be great.
Yeah. While I'm doing that, Mr. Rooney, if you have any critique,
Yeah.
please give it, because these kids got to eat lunch before their next round.
Absolutely. I just really echo the fellow scoring panelists. You guys all did a great job. I think this really shows kind of the importance of knowing the rules of evidence in something like this. But I think both sides did a great job in knowing those rules. Again, I know it's very nerve-wracking to do these things myself. Even doing public speaking I still need practice myself. So you guys both did an excellent job, though.
Mr. Rooney, Lance just texted me. He got it.
Perfect.
So good luck, everyone, for the rest of the day. And I am going to adjourn this meeting if I can figure out how to do it.
Thank you.
Thank you, everyone.
Thank you, guys. Good job.
Okay, I'm ending.